Well, everything should now be working. Everything should now be working. You'll have to be the person who tells me whether the audio's fine. That was a little bit of a nightmare, just to say the absolute least. That was some sort of special. Nearly broke my neck, tripping over my headphone wires that were still attached to my head and attached to the desk and attached to my foot all simultaneously. So I think that was absolutely fine. What seemed to be the problem was that one of the leads I had plugged in shouldn't have been plugged in. Then, on top of that, a program that I had running on the background, that shouldn't have been running. So that was all a bit of a complete and utter, nightmare. But as you can see, I've adapted the original live and put it as a sound test so people can see a disaster in action. What is that doing up there? Yours is now coming on. So, if you can hear me fine, give me a thumbs up in chat. Can you do thumbs up? If you've got like a phone, you can do like emojis. So, do either a thumbs up or a, say, yes, I can hear you. Woo! Woo! I think that's good. Now, this is the test. This is the thing that tests it all. So if I now go onto this screen, I've got to wait for it to go on up that screen, but you can tell me whether I am echoing or not when I'm sharing this screen. And hopefully, that's not echoing. Echo cancellation there. I've turned echo cancellation on. Hopefully, you are sorted. You're about 40 seconds behind me. But hopefully there is no echo. Yes, we've done it. We've done it. That's got to be a. Oh yeah. Yes. I've done it. I've done it. I've done it. Can I just say that everything that you've experienced in the last sort of 45 minutes was completely planned. Mrs. Haas said, "Look, I think they could do with a laugh. They could do with being entertained." And so that's what I did. I thought I would stage all of this. I know it made me look incompetent, but when you think that this was purposeful, it was absolutely done on purpose. I'm sure that you can understand that. I'm a creator of fun. So we've got 113 people in. We've got 51 likes. Come on, we done better than that last time when we was having a fucking nightmare. So come on. Member for 2 months, January Milliken. Thank you very much for being a member. Thank you all for being members who are members. We shall do a roll call on the mods. I know that they're all in because they've all been giving me fucking stick. Kenny's in, Dope Soul is in, Superior is in, Karen's in, My May is in, Tracy is in. And we've got Mysterious Headlines is in. You're going to have a shorter name. So we call you Head or Mysterious or Lines. We'll call you Lines. So there we go. Look, we've done it. We've done it. You laughed when I tripped over and nearly hurt myself. Not that dramatic. I could have died. I could have been dead. And you was laughing. I'm not a drama queen. I could have hurt myself really badly. I'd have been doing the live and I'd have just been like a little head on the I don't know, on the floor or something. What was that? When I done that chair, yeah. For those of you who have been around the channel a while, you'll probably remember when I had my chair delivery. I was waiting for months for that chair, and the day it turned up, I thought I'm going to do a video, and I fell over and snapped the mic off my phone. That was planned as well. Planned, completely planned. So yes, there we go. Anyway, how is everyone? I hope you've had a wonderful evening. And you've joined us just in time for a live, which we definitely knew what time it was going to happen, and we've managed to get here just in time for it. But did you die? But did you die? That is Mrs. Harsh's favourite phrase when I question her driving ability. Usually when she's nearly drove us straight into a bush. But did you die? Yeah. I've had everything. Yeah, that was planned. Everything's planned. Absolute everything. Everything I do is just always planned. 99% of the time. Well, we're done. Woo! Yeah, we had a bit of a wrestle chat the other night. We were talking about wrestling. Did it echo though? Not this time. Not this time. I sorted the problem. Sorted it. I knew it was going to echo before I even started. I don't even know why I didn't sort it before I come live. Maybe I just thought no one had noticed that they kept hearing everything I said twice. But no, we got there. Something's going on with the light, you know. I can do that. Is that going to be... You can't see my hands anyway, so I'll just do that. That look all right, doesn't it? That works out. The light. I'll do that. It's a bit better. Bit better. Bit better. I could turn it down a little bit so it doesn't blind my hands. Why is it not lighting up? Oh no. I think I kicked that. Like, it goes on and off. Oh, here we go, look. Is that going bright? That's going brighter. Oh no, that's temperature. No, that's making me go fucking green. What's going on there? Don't want to go green, do I? Oh my good lord. Stop touching buttons. Stop, I've been told. Stop pressing stuff. Anyway, we are here. We are here. Hush, you are great. You know how to entertain. Now keep Mrs. H away from your computer. She messed it up. If I said that to her, you'd see someone come flying towards me. Smash subscribe, like notification, and share. I'm also putting stuff back on to TikTok as well. So what I'll probably do is I'll do videos and then put little like teaser segments over there so you can see what videos are up tomorrow. And if you're on TikTok and follow me, you'll already know there's one up there today from tomorrow. Do you drive? Yes. And believe it or not, touch wood, I have never ever crashed, ever. We've been hit, weren't we? We did get hit just before COVID, wasn't it? We got hit from behind. But there we go. But let's see what's going on Judge John Judge. Nothing so far, but we have got 15 minutes. They might start getting in a little bit earlier. But don't push any more buttons. Luckily, that button's nothing to do with the computer. That's that light thing. Look, that's to control one of the lights in front of me. Well, actually up there somewhere. But I don't know whether that's making me look green, you know. That makes me look green. That's better. If I go that way, that's fine. That was making me look green, look like an alien. Gone Girl just became a member. Good on you. Must like watching people have complete and utter disasters. Hit the like button. It's free. Idaho forecourt here and live. That's what we're doing. That's what we've been doing all night. Hi, new in here. Hello. We have newbie. Welcome the newbie. Chrissy's Corner for Collectors. Hello, Chrissy's Corner for Collectors. You've come to the right place if you want to watch absolute disasters. Because tonight has been an absolute disaster. But we have done 2 lives. We have done 2 lives. If you can call the first one a live. Kind of a bit of a disaster. But we're just waiting for Judge John Judge to come in. You know what's going to happen now, don't you? This isn't going to be streamed. And I'm going to quit doing lives forever. Gifted 5 harsh reality memberships. And who got one? Kathy Stacy got one. Steve Shadow got one. J9 Wheels got one. Zella Murillo got one. And Licity J. Congratulations. You are now stuck watching me for the next month. Because you can't leave. Once you remember, that's it. You're done. just end. What we're doing? Oh, what? Look down here. Tonight has been so much fun. Enjoy the ride. It's been a complete and utter nightmare. But we got there in the end. Come on, Judge John Judge. Come on, everyone. I'm just refreshing the screen. The first one was funny. Yeah, that would have been even funny if it had watched me and Ellie go arse over tit. That coffee's quite good. I made one earlier and that tasted like dishwater. And then Mrs. Harsh made one that actually tastes like coffee this time. Are you going to follow me back on TikTok? I might do. I haven't been going on there. I had an account. I think I've got like nearly 9,000 followers on there, who probably all think that I died. But yeah, I'm on there. Oh my gosh. I'm trying not to crash while I'm driving home from the store. Thank you so much for the membership. Harsh may not be too happy that I have one. No, you're allowed one. Anyone can have one. Should already know he's gonna screw Anne either way, ain't he just? Let's see how much arse over tit bingo. Bingo. Perfect voice sound this time. Thank you very much. Yeah, to be fair, it wasn't entirely my fault. For some reason, the computer had opened up another audio program in the background, and I think it was trying to put the audio through both of them. So yeah, that was a bit of a disaster. April Young, £10 to buy a new clock. Yeah, I think I'll ignore that one. Mind you, it's not the new clock that I need, Anne. To be fair, the clock works fine. That's my ability to tell the time, which is quite questionable. That's seemingly the problem. The fact that I can't tell the time. So what I might do is use what you've given me there for a clock reading lesson. But yeah, where you move the hands. Right, what's this? Harsh, what's this time? Where's the little hand? Where's the little hand pointing? And where's the upper one? Arse over tit. Arse over tit. You think that is what happens though? I think that is literally what nearly happened. I literally did nearly go arse over tit. I'm not even joking. That is what happened. I've never crashed a car, but I didn't take my test either. True story. My mate, on his, I think that was like his 17th try at trying to pass, he was heading down the road, going quite quickly towards, there was parked cars and there was a bus on that side. And he was heading towards it, weren't slowing up, and the driving instructor went to him, "Do you think that you're going to fit through there?" And my mate turned around and went, "I don't know, but I'm going to give it a go." At that point, he slammed on the brakes and went, "I can tell you now, you weren't going to make it through there." Yeah, that was another fail. His 18th fail in a row. He passed. I never got in the car with him. But another true story, same person, hassled me like hell to buy a car off me. Hassle. And I went, all right. He wanted to drive it from, I let him buy it. He wanted to drive it from mine to his. I went, no, if you're driving it from mine to yours, you're paying for it first, not when we get there. He went, all right. Anyway, I got to his first and he was driving the car. He goes past me, fine, but then goes to reverse back up the road. And this is when the Football World Cup was on. And he reverses it straight into a car that's parked on a bend with its wheel kicked out. Doesn't realise he's hit the car, so he slams it again and revs it up, and it ends up on the bonnet, nearly going through the windscreen of the car. The bits blew off the car and was up on the bridge that ran over the road that he lived down. He was absolute fucking terrible at driving. He probably is still terrible at driving, to be fair. But yeah, what an absolute div. Anyway, Harsh today Harsh said Adam and Eve. Yeah, do you Adam and Eve it? I had a Brit, a Scot, and an Irishman on a crew in DC once. Most fun I ever had, I can imagine. Millennial Phoenix has joined as a member as well. Hello, welcome aboard. We're all completely normal here. All completely normal. I'm drinking this coffee. Look at these cups, look. Mrs. House got me that. She done that, look. Picture of me giving the bird, which is something that I do quite regularly. Yeah, quite regularly. Just waiting for the court men to come in, court men and ladies. Apparently, we've got 9 minutes. Come on, Judge. Jesus. What do we got? What do we got? What do we got? So we've had some gifted memberships. We've got a few members in. We've got a few members. We've got the mods in, the mod team, who saved me from looking stupid. Didn't work tonight, mind. But I thought there was a joke starting there. No, it wasn't even a joke. It was literally serious. Thank you for the bonnet definition. The hood. Don't they call it the hood? This is as normal as it gets. This is pretty much as normal as it gets. Has to look up Kevin West, Washhugal, firefighter accused of murder and wife. I think I've heard of this thing about a firefighter accused of murdering his wife. West Washhugal. Well, I'm not going to touch anything at the minute just to mess that up. I'm not going to do anything at the minute. We have 5 children. We have 5. 4. You know what we was talking about the other night as well, where if you had one of them first, you'd have only had one. Yeah, we've got that as well. What's going on with the screen? But yeah, we've got 5, haven't we? We could try and sell a couple. One of them is actually normally in chat winding me up, but she must have fell asleep because she's lazy. I can say that when she's not in there. Yeah, if she was here, I wouldn't dare say it. She's worse than what I am. Right, let's have a look. I've been following Harsh Reality since the olden days, as my mum used to say. Just getting back into the swing of YT, though. We've been around a bit. Let's reset that. See what's going on. Come on, Judge. See if a silly twat fucking starts it. This, like I say, this is when we realise that it's grandkids, grandchildren. Which one of the children is going to have children first? Oh, I don't know. I don't know. Hopefully none for a very long while. Yeah, hopefully none ever. How old is your oldest, Harsh, if you don't mind me asking? Sienna's the oldest, and Sienna is 18 on the 16th in 6 days. 16th of April. She is, which I actually forgot about until earlier. But I do forget about my own birthday, so 5 kids, that's a lot, yeah. That's like if you've done something really bad. That's like a prison sentence. That's like you're being punished from something you did in a past life some days. Other days is brilliant. Some days you just want to jump off the roof. But yeah. Have kids. It's fun, they said. It's fun. 5, yes. Just have 2 boys. Yeah, see, boys, we don't have any problems with the boy, do we? No problems whatsoever. Like I say, some of you who have been around the channel for a while, you would have, you'll know 2 of them. Definitely 2. You don't look old enough to have an 18-year-old. You can come again, Helen. You can come again. But I am only 21. So work that out. My daughter is 25, Harsh. It's a lot harder when your daughters grow up than when your sons do. Yeah, because there's nobody who's probably going to get their legs broken because they go out with your son. I won't buy a gun because my son's dating. That's a dead cert. But I can probably tell you I'm going to buy a couple when the girls do. Mind you, they're all right, aren't they? Sienna's quite settled, isn't she? They're now buying a house, her and Jack. Bless him. She bullies him to death. He needs to grow a set of balls. That's what he needs to do. Bless him. Oh, right. Do my 5 likes count? I don't know. I think they probably do. We've got 194 likes and we've got 408 people in there, so we're slacking like frick. Come on, look. 21 in doggy years, you cheeky fucker. Now, what is it? Is it like, oh, what am I doing? I'm pressing the wrong button. Come on, Judge. Live, come on. What's going on? My daughter is 10 and thinks she's 30. My son's 8 and thinks he's 21. Yeah, that's about right, my friend. That's about right. Yeah, 8-year-old son. Yeah, that's Hayden. How's Hayden's 11 next birthday? Yeah, he's 10 now. Yeah. 10 and 8. And you do it on your own as well, don't you, Metalhead? You do it on your own. 10-year-old daughter and 8-year-old son. You, my friend, are a damn hero. Come on, Judge. What's going on? We've been sitting here waiting patiently for the last hour and 17 minutes. I have a son. I enjoyed raising him. Yes, sons are good to raise. They're fantastic. Girls, not so much. Not so much. But, you know, hit that like you mean it. Yes. Hit it. Let's see if we can get over 350 likes by the time Judge John Judge decides to turn the camera on. Come on, Judge John Judge. What are you doing? Don't make poo lives this evening be a complete disaster. Mind you, we are early. 23:58. You'd think they'd turn the fucking camera on by now, wouldn't you? When they say 4 o'clock, is it like you've got to get in here first and we're going to be ready to go for 4 o'clock? Or is it they start walking in the room at 4 o'clock? See, I used to make people, when I was bossing people, I used to say you need to be in here ready and sitting down when the clock's on your time, not walking in on your time. I wonder what Bryan Kohberger will be wearing today. Do you think he'll be looking like a human being? That'll piss the Gonsalves family off. He looks like a human. Yes, that's because he is one. But there we go. I've got slow mode on. If I have to adjust slow mode, can either... Who do I want to blame if all goes wrong? Dope, you. So if the slow mode needs to go up or down, you can tell me. So, like I say, if all goes wrong, you can take responsibility for it. 8-year-olds always do, Metalhead. It's a good age. Hey, Haj, you big handsome bowl of vanilla ice cream. I don't like ice cream. I don't like vanilla ice cream. Come on. I just can't with them. Yeah, I don't know. That interview, the more I think about that interview and the things they said, you know what I mean? It was a bit of a car crash. Like I say, I do feel sorry for what happened to him, 100%. I've got, you know, all the empathy in the world. But, yeah. Yes, this was the migraines, wasn't it? A few of you guys in the community said, give Hayden some vitamin tablets. Now, he probably wouldn't be so happy about it and giving you praise because he hates taking them. But yeah, he's not had a migraine since he started taking the vitamins, which is crazy. I heard boys suck to raise, not in comparison to girls. I can promise you that. Not in our experience, anyway. Come on. It's now 4 o'clock. Come on, why are we waiting? Come on, Judge. Come on, Judge. What's your favourite ice cream? Mine is Ben & Jerry's chocolate fudge brownie. Ooh, favourite ice cream? Probably Bailey's. Is it the Ben & Jerry's Bailey's? Do they do it? Bailey's ice cream, something like that. I don't know. Mint choc chip, probably. I like mint choc chip. Judge stalling in the stall. Come on. Think how his family feel here, and the son isn't who I know. It's just this bad. It is bad. Do you know what I mean? But that's just the complete lack of just humanity in it. That's where what's going on with this world. You know, we was watching Bones again earlier, weren't we? Yeah. We've been watching Bones, and you know, little things that are said and that. And it's like like tonight, it was a statement that was made, and it was that taking any life shouldn't be easy. And you know, even Bryan Kohberger, do you know what I mean? If he did it, he did it, but it still shouldn't be easy or, you know, a nice thing to think. Oh well, it's another person being put to death. That's just another fucking part of this tragedy, isn't it? Do you know what I mean? It's not. It's not a good thing. That's a tragedy. You know, what makes people do what they do if he did it? You know, but people don't care. They don't care. I just want him not to be breathing anymore. But there we go. Hi, people coming in. Hello. I don't know what's going on. Beetlejuice. Fuck around and find out. That dead kid is just one less piece of shit walking around. Again, we haven't yet got a definitive answer as to whether he's done it. He's live now. Ooh, let's go. He's live now. Not on my fucking screen, he ain't. Oh, yes, he is. He's not on the live thing. That's it. There he is. Hold on. Let's go. What I'll do, I'll get this up, and then I'll adjust the screen somewhat.
Thompson is Jennings representing the state. Can you hear me okay?
Yes.
Don't worry, okay. I'm going to change the screen.
I think we have Mr. Nye and Ms. Beatty on Zoom.
I'll get me out of the way, don't worry.
On Zoom? Ms. Taylor?
No, Mr. Logston is not going to be on Zoom today. He had the other hearing.
Ms. Beatty made it apparently. So, and I have also, you have Mr. Edelman, Dr. Edelman here today.
I do, Your Honor.
Okay. Great. So I think what we're doing today is just a continuation about the questions, particularly on the surveys and where we go from here. You did drop off a sealed exhibit, right? Anything to say about this, or just?
Yes, Your Honor. That sealed exhibit goes with one of our discovery requests, that the exhibit that outlines what we're requesting has to be under seal. And so I had to hand deliver that to the court. A copy was hand delivered to the state. It is not up for discussion today.
Okay, great. Thank you. One other thing to just tie up is the order unsealing the state's motion for order prohibiting contact with prospective jurors. There was a discussion between both of you about redacting a particular sentence, maybe last time, and so that we were going to take care of that.
I didn't. Ms. Taylor indicated that there was a sentence she thought we might want to consider redacting. I haven't heard back on that, and I know that she's been busy on other things since the 6th.
You want to just talk to each other for a second?
I can. I understand the microphones in the courtroom are very sensitive. Perhaps we should do this after court today and go ahead and do the testimony of Dr. Edelman first. And I'd be happy to talk to the state afterwards.
Right. All right. So is that where we're starting now?
Yes, Your Honor.
Actually, Judge, I think we need to discuss some preliminary matters first.
Okay, go ahead.
As Your Honor indicated just a moment ago, this is a continuation of where we were on the 6th. And the issues on the 6th and the issues that we have here today is first, whether there was violation of the non-dissemination order. And if so, where do we go forward from that point? And I think it was clear from our discussions on the 6th that the fact-specific questions did violate the order. I realize that the defense would like to proceed with those questions. That's perhaps an issue for today. But I just wanted to define what we're looking at today, because about 10:45 this morning, we got what was up on the screen there, a PowerPoint that apparently Mr. Edelman prepared. And as I understand, I don't think Ms. Taylor got it until sometime this morning herself. That's the information that I was given. And we have concerns because a large part of this PowerPoint deals with the issue of a change of venue itself, which is we are not prepared to address. It is not before the court at this time. It is premature. And I don't think that it should be part of this record as we proceed forward today. And so the state took a copy of preparing a printout of the PowerPoint. It doesn't take long to look through it. Perhaps the court might want to take a look at that before we proceed, at least with eliciting things from the PowerPoint. And I realize it's last minute, but the last time that we presented something to the court in advance, Ms. Taylor complained profusely. And I realized it was only 10:45 when we got this today. And so we just figured we would raise it with you now.
Okay, thank you, Mr. Thompson. Ms. Taylor?
He had to have a little dig, didn't he?
Yep.
Bill
Your Honor, I
Thompson.
would disagree with counsel that the court made a determination that we violated the non-dissemination order. In my mind, that issue is very right for the court today, as is where do we go from here with the survey? Dr. Edelman has made himself available in court to explain the survey, the process of the survey, why it works, how long it's been used, how widely it's used, and what it doesn't do, and what it does do to present the court with some options to make a decision where we go from here. Whether the court decides we violated the non-dissemination order or not is up for discussion, and we're prepared to further argue that, but we think you need to hear the testimony first. As far as this PowerPoint, I had access to Dr. Edelman yesterday afternoon, and we worked on it late. I didn't have a final copy to give to the state until this morning. So they have it. We are not arguing venue now. We're talking about survey and how that relates to our change of venue motion. We know we're arguing the venue change later, but we have work that we still need to do. And that's where we are today, and would ask to present our PowerPoint and present our testimony with Dr. Edelman as we've prepared to do.
Okay.
You tell her, man.
Actually, Your Honor, Ms. Taylor still has a copy of the PowerPoint that made available to the court.
Okay, so it seems like this happens to me in this case, that there's an argument about whether I should go ahead on something or provide some information that I don't see yet. So I feel like sometimes I'm making decisions that I'm in the blind here. So I'm gonna look this over. Any problem with that, Ms. Taylor?
Judge, give me just 1 second.
He just wants to get out, doesn't he?
Your Honor, the purpose of the PowerPoint is to inform the court about the questions in the survey and the purpose of them. I can tell the court that showing up every time we want to have a hearing and have to fight to have the actual hearing is something I haven't experienced before either. There is nothing in that PowerPoint that the court can't hear today when making the decision about where do we go from here and did I violate the non-dissemination order. There's just nothing wrong with the process that we're doing here, and you're continually being asked to say there's something wrong with what we're doing. We're 10 after 4. I have a witness who's traveled here today, and we're ready to go.
Good on you, Ann.
All right, Your Honor, just to
Sit
clarify.
down, fat
As
twat.
we made clear the last time we reported, we are not saying Ms. Taylor herself violated the non-dissemination rule. We're saying that the people who prepared the survey and disseminated the survey and called citizens of Latah County with those fact-specific loaded questions violated the non-dissemination order, and they are agents of the defense. So I don't want this to become personal between Ms. Taylor and myself. We are not alleging Ms. Taylor has done anything wrong. We are dealing with reality that this survey was conducted on, as we understand it, 400, I'll say, innocent citizens of Latah County who were force-fed information that they may or may not have had about this case before they were called by the surveyor takers. And they are loaded questions. Some of the questions are factually wrong. They simply aren't true. That's what we're here about.
And that's what we're prepared to address, Your Honor. That's why we have a witness here. And if there's violation of the non-dissemination order, it's me. I'm the one that's bound by it. And the court just needs to hear about this process instead of hearing the conclusion that the state wants the court to reach.
Good on
Number
you.
one, I'm past that. I'm not going to violate you. I mean, this was a communication problem with Dr. Edelman not getting the order.
Oh, he's twisting it now.
One of the things I think that maybe need to clear up, not for counsel, but maybe the public, is that one of the terms in that, and this is in the ethics, right, is what is the public record? Public record is not
I'm not going to
traditional
violate
media.
you.
It's
Famous
not
last word.
social media. It's not what anyone might say in public. Okay, that's the problem that we're kind of balancing here, because the public record is case that is available to the public in this case. I mean, I think we can all agree with that. No?
No.
You think the public record is whatever the media pumps out?
Your Honor, I think it's what's in the public, and what's in the public is derived from the affidavit that supported probable cause to arrest Bryan Kohberger. That's the first document that the court finds in the whole cases of interest on Idaho State Supreme Court's website. That document has a ton of information in it that relate to the questions in the survey for the case-specific questions. So that document became public record, and that was spread far and wide all over the place and reported and interpreted repeatedly. That's the public record. That's where the questions came from. There's no violation of the non-dissemination order if that's what we're going to talk about today, but I think the court should hear from our witness and understand a little bit more about this survey process.
I'm very interested in that. I told you last time that I'm interested in what he has to say about this, but so you're saying that the public record, though, comes out of the case, right? That's public.
I'm saying in this case, that's exactly what happened, Judge. I don't want to argue the finer points of what's in the media, but I'm saying in this case, that's exactly what happened. That affidavit's there, and this court knows we have a ton of things that are filed under seal and more things that are not filed under seal. But that affidavit that began this case has been shared far and wide, and media stories have generated. When you understand how Dr. Edelman does his work to determine if a survey even needs to happen, you'll know where the information came from.
Okay, so I'm understanding, okay, the initial probable cause affidavit is part of the public record. And you're saying, well, that got spread, okay, by the media, as you would expect. And that's something that could be concerned. So what I think maybe, I don't know, what Mr. Thompson is talking about, though, is information or questions that were not in the public record. And so what I'm nervous about this is I don't want to continue to spread things out that shouldn't be spread. And so I don't know what's in the slides, but if there's information in the slides that are not in the public record, that really have not been disseminated generally, then I mean, I don't really want to spread it. None of us want to spread it more than necessary.
Well, last week in court, that was right inside the courtroom. That all became part of the public record. The 9 questions were stated repeatedly in different formats by Mr. Thompson. That's part of the public record. We've been accused of violating the non-dissemination order. Dr. Edelman's reputation has been impugned by what was stated about him repeatedly. Those questions are fair game. But having this hearing and allowing our expert to talk about this process, that's not the problem. The problem with the media happened a long time ago, and it started with the sharing of the affidavit far and wide.
I understand that. I'm pulled in 2 different directions
You
right
don't
now
want to. You
because
don't want to let that guy
I'm
out to
trying
talk.
to protect your client at the same time. So if we keep talking about this, what is not true, okay? I mean, I guess we can just say, well, it's not true on some of these questions. Maybe that helps to reduce bias. But if we don't make that clear, then it could increase bias. I think. I don't know, tell me, maybe
Well,
I'll hear this from the expert.
I'm going to say it like this. Mr. Kohberger is my client, and his rights are of the utmost importance to me. Him being treated fair, his presumption of innocence, him having an impartial jury, those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about this survey. Let me finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias and that you shouldn't have a trial in this county. What I'm trying to do is say, do you want me to give you information about another place where maybe the bias isn't so great, where maybe Mr. Kohberger can have a fair trial? I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all. I need you to hear the information so you can make a decision, to have the surveys, to have the information when we come back here for change of venue and make a decision on all of the information. Right now, if we come in and do our change of venue, we're going to say you can't have this jury in Latah County, but I can't tell you a better place that will protect him better. And that's what I want to do.
Any response, Mr. Thompson?
We aren't here to argue about venue today. We aren't here to argue about what this particular survey with the loaded questions, fact-loaded questions, may have produced in Latah County residents. As we mentioned last week, the structure of those questions assumes that every person that is called has heard all of the media in this case. And we know that that just simply isn't true. So for those citizens in this county who have not heard all of the rumors, who have not been following the media, who haven't inspected the court record, who are essentially ignorant of facts in this case, well, that's just been jaundiced by the questions that were asked. They have now been force-fed facts, some of which are not true, some of which would not be offered in court, and in fact, probably wouldn't legally be admissible in court, to somebody who may never have heard them before. That's the state's concern about the way this thing is put together. And the arguments from the defense seem to be completely ignoring that point. That there are people out here who don't know all the things that they were being asked. And by asking the fact-specific questions, we were inoculating them with information that they didn't have before about this case that could affect their ability to sit as jurors. It's just simply irresponsible. It doesn't make sense.
Listen, this is one of the things that I was thinking about is maybe we can inoculate by saying you can't rely on any of this information. It's not established by evidence. It's not been provided in court. But to just send a message out to be clear that these questions have nothing to do with guilt or innocence or even truth.
But that's not what was done, Judge.
I know, we have to fix this in some way.
Yes, sir.
That's what you
Nothing
said
to
last
fix,
time. And
is there?
so
Guy did a
I
survey.
just want to help the public understand that this is not the trial.
Your Honor,
Yes,
at this rate, we may never get to trial. We know this isn't the trial. We brought Dr. Edelman to talk about the process, which will answer the state's concerns about this process.
Get
He
the
hasn't
guy
even
up.
had a chance to tell you how this is constructed. He's the one that's the doctor of this kind of work. He's the one that's the professional. He's the one that knows how to do this. He's the one that spent his career understanding surveys and how to construct these. You need to hear from him. Going back and forth between what Bill thinks and what I think doesn't matter. What matters is you hearing from the expert to make a decision. He's here, he's ready to testify. We're 20 minutes into this hearing and he hasn't been allowed to take the stand yet. He came to inform the court about this process.
well, there's no question I'm gonna let him testify.
Well, shut the
I
fuck up
just
and
want
do
to
it
hear
then.
about what's in this. I haven't even looked at this, but it's, you're comfortable having this come out into the public?
Yes, after last week's hearing, absolutely.
Okay, and you looked at it, Mr.
You
Thompson?
have
Is it-
concerns,
Is
Judge.
it alarming?
Well, part of what's in there is a part of the survey study being published now, if this comes to the public without any comparison to anything else. And it's the product of these loaded questions. It takes us back to the fundamental issue of how this survey was conducted and the assumption that the people who were being called already knew all this stuff. And so it didn't hurt to specifically ask them, have you heard about such, such, and such?
But it's in the public, Bill.
Well, if they hadn't heard about it before, they sure as heck have heard about it now.
And they could have heard about
That's
it in
the
the future.
core concern that led us to this in the first place.
Is
We
he
don't dispute the
purposefully
defense doing
being
a survey.
sick?
I said that last week. Please do a survey, but don't go around screwing with the knowledge that prospective jurors have or may not have. That's
Well,
our
what
concern.
do you talk about then, Bill?
And Your Honor, when we parted ways last week, the court said, Ms. Taylor, talk with Mr. Edelman and see what the options are. Well, my understanding from the email I received the day before yesterday is the survey cannot be changed. That was from Ms. Taylor reporting what Dr. Edelman said. I interpret that as they don't want to change it. Anything can be done, but that's where we're left. I would have been happy to engage in discussion with defense about
You must
maybe
do a
some middle
survey
ground,
that
but
I am happy
the
with.
line's been drawn black and white. I am concerned about the specific things that relate to venue, partial survey results that are in this PowerPoint. I believe it is premature for them to come out now. The rest of it is fine. Let's bring it out so that you have whatever information you want. You can give it the weight that you decide. I just didn't want to let this willy-nilly come into the public record in a half-baked fashion.
I have lots of concerns. We're not left with this because I have to make a decision about several things.
Yes, sir.
And so in order for me to have the most informed decision, I need the information. So we're just gonna go ahead. All right.
He's ruining
Thank you.
Christmas
And
for me.
You can show your slides, and if something is concerning, we can talk about it along with it. All right. So, are you ready to call your witness? I think you are.
I am. I'm ready to
I
call
think you
Dr.
are.
Bryan Edelman.
Okay, Dr.
Take the
Edelman, if
piss.
you could please come forward, face the clerk, raise your right hand. There you go.
You solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, thank you, sir. If you could please take your seat there. And then once you're comfortable, please state your name and spell your last.
That won't be,
It's
by the way.
Bryan Edelman, Bryan Edelman.
Thank you. Ms.
Thank you.
Taylor.
Good afternoon, Dr. Edelman.
Good afternoon.
What do you do for a living?
I work as a trial consultant, and also I do quite a bit of work as an expert witness in the field of pretrial publicity and change events.
Are those two separate roles?
Yes, they are.
What do you do when you're a trial consultant?
So as a trial consultant, you're an advocate for your client. You do mock trials, focus groups, to really try to develop a trial strategy, a trial story for your side, and cultivate that for the audience, the jury. We also do jury selection. I assist with writing voir dire questions, juror questionnaires, help ferret out bias during voir dire, recommend cause challenges and how we use peremptories. I do post-trial interviews. I do jury-related research, present my findings at conferences, bar associations, law firms, and so on.
When you work as an expert in the field of change of venue, does that differ from your work as a trial consultant?
Absolutely.
How so?
Well, as I mentioned, as a trial consultant, you're retained to be an advocate. As an expert, you are retained to be an objective expert, which means I'm not advocating for either side. I do not advocate for the defense. I do not advocate for the prosecution. My role is to collect information using standard methods that have been widely accepted in the field, and then present the findings to the court so they can make a well-informed decision on whether or not any remedial measures are necessary. So there are times where my findings support what remedial measures, like a change of venue, and there are times they don't. And when they don't, I recommend against a change of venue, whatever the data supports where I go.
I want to understand a little bit about your educational background that allows you to do that work.
Okay.
How were you educated?
I'm sorry?
How were you educated? What degree?
Starting in grammar school.
We can skip to college.
Yeah. So I have a bachelor's degree in psychology from Florida State University. From there, I attended the University of Nevada in Reno, where I studied social psychology. My particular interest was in the application of social psychology in the field of the legal arena. So I was really interested in juror decision-making, jury decision-making, group dynamics, how people process information and evidence, the impact on pretrial publicity, pre-existing attitudes, and that sort of thing. The school I went to really focused on that area. That's where the National Judicial College is, the Grant Sawyer Center for Justice Studies, and several professors in that field. So I conducted research at the Grant Sawyer Center for Justice Studies. I helped run a program through the Department of State that brought in judges and attorneys to the United States, where they would travel around the country and meet with people in their field. So I worked with the National Judicial College in that regard as well. And then from there, when I finished my PhD, I got a Rotary Scholarship to study in the United Kingdom, where I got an LLM in International Humanitarian Law, which I do not use.
During the course of your career, have you been published?
I have. I've been published in the area of survey methodology. My research was on the death penalty, so I have a book published on the death penalty. I am the co-editor in California. There's something called the CEB, the Continuing Education of the Bar, and there's a criminal procedure book that comes out every year. It's kind of like the Bible for criminal procedure, and I'm a co-editor on the chapter on change of venue. I was also on the committee for the American Society of Trial Consultants that publishes professional guidelines for writing change of venue surveys. So I'm on that. And I've also done research on, one of the questions is always, well, why can't we just pick a jury in a high profile case? So I've done research on the use of the set aside question. So if people have been inundated with a lot of prejudicial media coverage, how do they respond to that set aside question? Do we see, for example, if somebody's been exposed to a lot, I cannot be fair and impartial, I know too much. And so we were looking at research on that as well. And then last thing I promise is, I've also done research on what's called minimization language. So when you ask people an open-ended question on a juror questionnaire or in voir dire in a high-profile case, this is the only standard question, what have you read, seen, or heard about this case? That's the open-ended question. And people minimize what they know. That's something Dr. Ed Bronson came up with because he had noticed it. And that's like using language such as I only recall what was in the paper, or I just followed it. I just remember it was on the news, and they don't really elicit a lot of information. It's minimized knowledge. So did research on that.
That's been part of your research?
Yes.
When you work as an expert, if you're hired as an expert to work on a change of view issue, and I think you told us how your work is different than when you're a trial consultant. Can you tell me how you start in that role as an expert for change of venue?
Yeah. So I've been doing this for about 15 years, I'd say, as an expert witness on this area.
On change of venue
On change of
specifically? Okay.
And
to do
I'm
with
still
surveys,
here.
just to be
yes,
clear.
yes.
The camera's just
It's
decided to
surveys,
go
sometimes
off.
it's post-conviction, once again. I've done it federal cases, state cases, multiple states, including Idaho. But the way I learned was from Dr. Ed Bronson, who was kind of the pioneer in the field. He worked on cases like the Oklahoma City bombing case and a host of other prominent ones, the Boston Marathon, a bunch of them. So he was kind of my mentor in this area. And there's a 3-stage process. So the first phase is collecting the media coverage. Because really the question is initially, is there extensive coverage and is there prejudicial coverage? So I collect the coverage and assess the nature of that coverage. Does it include inflammatory language? Does it include inadmissible or misinformation? Now, just because it's not true does not mean people don't see it. And it does not mean that they don't develop opinions based on that information. So it's very important. In fact, some of that stuff is the most prejudicial stuff that there can possibly be. For example, if there is a prior conviction and then the conviction's thrown out, well, that's pretty prejudicial for the new trial. Not admissible, but very prejudicial. So I'm looking for information like that. I'm looking for references to prior records. Maybe there are victim impact statements where the victims' families may be suggesting what the outcome should be. That could be prejudicial. How did the community respond? Are there candlelight vigils? Are there, GoFundMe efforts going on? The status of the victim, is it focusing on that? So there's a gambit of things that we look at. Sometimes there's political elements that are important in high-profile cases because it might be that a politician's involved. So it just depends on the case. So the first thing is assessing the nature of the publicity. Now, if there's not a lot of extensive pretrial publicity and it's not prejudicial, it stops there. And that's happened where there's coverage, but it's very superficial. It's very neutral. There's not a lot of detail. There's nothing particularly impactful. Maybe it's focused primarily on just the victim or something like that. However, there are other cases where there is extensive pretrial publicity, and then I would recommend phase 2, which is a community attitude survey. Because just because there's prejudicial coverage does not mean it had an impact on the jury pool. And that is the question that matters most. What impact has the prejudicial media coverage had on the jury pool? I don't really care if it's correct information, it came from social media, it came from the news. It had an impact on the jury pool. That's what matters because they develop opinions and attitudes. And it doesn't make a difference if that fact is true or false. They still develop an opinion and an attitude about the defendant, about the evidence and perceptions of guilt. All of that is what I'm looking at. So I want to see if the media coverage has had an impact. And that's why we do a community attitude survey. And then depending on the results of the survey, we year. Maybe that's appropriate in some cases, all the way to the extreme case where it might be a change of venue.
I want to understand a little bit about the source of media you review to do your work. Can you tell me what you take a look at?
I always take a conservative.
Your Honor, I'm sorry, I need to object. This PowerPoint is being played for everybody with no foundation. It's not an exhibit. I think that's improper. I mean, I'm trying to listen to Dr. Edelman's testimony, and I keep seeing slides changing in front of me over here, and I don't think that's appropriate.
Well, you've seen the slides.
I have,
You looked at
but
them.
everybody else here hasn't.
What I'm seeing here, though, is just an explanation of how he goes about in surveys.
Understand that. That's what his testimony is, but we're getting this visual aid that there's no foundation for, Judge.
Well,
It just seems highly unusual.
well, hold on. I'm viewing him as an expert.
Yes, sir.
Okay? He's explaining what he does. So I'm going
No
to,
problem with that. The PowerPoint's a problem. I don't have any problem with his testimony.
Unknown.
all right.
I'm sorry. I
Yeah.
frankly, I've never seen
No,
something like this
that-
occur.
That objection. I mean, this is not necessarily factual. It's just an example of how he got to where he got.
That's his testimony, but the PowerPoint is different, Judge. I don't know why we're seeing the PowerPoint when we have his testimony.
You want to respond to that?
I do,
Okay.
Judge. This is a courtroom demonstrative aid that helps to track the testimony of Dr. Edelman. I can hand him my computer and let him advance the screens if that makes a big difference in it. This just helps explain his testimony.
Judge, we don't have a jury here. Let's just proceed.
Thank you. Go ahead.
Dr. Edelman, we were talking about where you get your information.
We were talking about the what?
Where you get your information. What media do you look at? I think that's where it was.
Yes. So I take a conservative approach to how I do it. I look at newspapers in the local coverage right now. So I'm interested in papers that have primary circulation in the venue. Case like this has been reported in many other newspapers, but I wouldn't, for example, look at a newspaper published in Dallas because I don't know if somebody in Latah County would be looking at a paper in Dallas. So I look at the local coverage. I try to look at like local television coverage to see what the community is likely exposed to.
While we're here, I want to ask you some questions about the non-dissemination order.
Okay.
That's been a hot topic and you've heard some of it again today. Are you aware that there's a non-dissemination order in this case?
Yes.
How did you become aware of it?
Well, the first time I became aware of it was when I was reading the newspaper coverage, because that was one of the topics of media coverage, was discussing the non-dissemination order and media's efforts to have it changed. So I was able to read it and follow it.
Everyone
in that media
knows there's a
coverage.
gag
So that's
order.
the first time I saw it.
And in January, did you receive an email from my office with the non-dissemination order?
I believe I did.
And you looked at a hard copy again recently?
Yes.
All right. Does that non-dissemination order change how you did your work?
I'm sorry, can you know?
Does the existence of the non-dissemination order change how you did your work?
No, it did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
Was the sole source of the information that you used contained in the media?
Was it came from the media? Sorry. Yes. Everything I used was widely disseminated through the media. Widely disseminated.
Did you find out where the media got the information?
Yes.
Good afternoon, folks. My name is Bill Thompson. I'm the Latah County prosecutor. And it's sad to be here, but happy to be here at the same time.
You turn it up.
I can't hear.
Kohberger,
Well, I'm gonna do my best to turn this up.
Yeah, you don't have to.
If I put the microphone up, is that better?
So yeah, but Christie, you don't have to type out things that are recorded here.
and let me preface, there is a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all of the people who are interested and really need to know what's going on. So please have patience with us on that. We hope to get that to you as soon as we can.
In that clip, you heard reference to the probable cause affidavit.
Yes.
And did you hear reference to sharing it with all your readers and watchers?
Readers, watchers, and listeners, and anyone else who's interested.
Did your research tell you that the media took Mr. Thompson up on that offer to share this far and wide?
Yes.
Good afternoon, folks.
What did you see?
Basically, the media took that document and then published the highlights and key findings in that document and added editorial commentary to that information. So let's be clear, they didn't just read the affidavit. There's editorial, there's debate, there's discussion, there's spin, all of it in news stories. And these
Hello,
stories,
JB.
for example, this one has over 200, I'm sorry, I can't see it. Do you have a copy of the?
I do, Your Honor, I have a printed copy of his PowerPoint. If it would help him refresh his memory.
I just can't see it.
Sure, just go ahead.
Okay, thank you. So example, this one is on a local television station. On YouTube alone, 130,000 views and 224 comments. So people discussing it. That's just one example of how this document was disseminated through the media in this county, just as Mr. Thompson suggested during his press conference.
And did you check another media source and see that it continued to be shared?
Yes, this is a second example. And you can see just from the heading, it says court records unsealed. And then they go through a timeline, including information from that affidavit, highlighting all the key findings about the car and other things that are widely reported and disseminated from that document, to later saturating the community with prejudicial details from that document, which was reported in the press conference to be truthful as well. 54,000 views, 176 comments on just one other video of a news clip on YouTube.
And based on your research, did the story or stories continue to be shared far and wide?
Yes.
Janelle Finch is joining.
Cases received massive media coverage, saturating this county with prejudicial pretrial rules.
How about to social media?
It was also spread through social media, and people have talked about it on social media.
And do you know if misinformation and rumors ended up as a result of this information shared right from the start?
Yes, and the reason I looked at this and knew it was because in the media coverage, they discussed the spreading of rumors on social media. For example, a professor who was accused by a psychic of being responsible for this. Other references to questioning the implication of people knew about the crime before it was reported to the police and so on. So there's been quite a bit of discussion, spread of rumors, misinformation, factual information all over social media, which you'd expect in small communities such as this.
Did your review of all of this information tell you as a professional, as an expert in your field, that a survey was necessary in Bryan Kohberger's case?
Yes, based off of the media coverage that I reviewed, which was over 200 plus articles, and the television coverage, I thought it was appropriate to move forward to see what impact, if any, this coverage has had on the community.
What kind of survey did you think would be appropriate?
We always use random digit dial telephone surveys in these cases.
Before you tell me a little bit more about that, I want to understand the history of this kind of survey. Is this something that you just made up all on your own?
No.
Where does this come from?
So these surveys have been done for decades. The first one I recall that followed a similar design and focus on case-specific items was done in 1979. Constantini and King in 3 cases in Yolo County, California. This approach was done, Dr. Ed Bronson, who I mentioned, my mentor, had been using it for decades, 40 years or more. Other experts in the field do it. John Walker Lynn from the American Taliban case, they used a similar approach that was published as well. Used in Skilling, Boston Marathon. I've used it in countless cases, so hundreds of times, I would say.
Is there research that supports this process?
There is. One of the things we're looking at, so when you think about the survey, is the structure and how we test validity. So there's 40 plus years of social science literature on the impact of media coverage on juror and jury decision making. And one of the things it tells us, for example, is knowledge, or let's take a step back. People who regularly watch and listen to the news are more likely to know about the case. When I say know about the case, are more likely to have case-specific information from the media. So they test similar things like we did. Have you read, seen, or heard if ... And they assess how much knowledge does this person have, and then they correlate it with media consumption habits. And what you find is people that read the news regularly know more of these details than people who do not. And they find that the more information you have, the more likely you are to hold an opinion regarding the defendant's guilt or innocence. So those are some of the findings, and we craft the survey similar to the others because we want to test the validity of the survey. So if we know we should see these relationships, we should expect to see them in our survey. So we ask the same similar types of questions, and then we look at those relationships to see if we see the same thing. That's one of the ways we test the validity of the survey.
Would this be considered a methodology in your field to do surveys in this certain format?
Yes, it's standard practice. We look at APOR, which is called the American Association of Public Opinion Research, American Society of Trial Consultants. They have professional code on how to conduct surveys, venue surveys. Those are the primary ones I look at. And again, I've taken course training during my program on how to craft surveys, how to write questions, all of that type of thing. I've done it hundreds of times, testified about it. So that's kind of the basis of how I craft this.
And I heard you mention standards and validity.
Mm-hmm.
Why are there standards? Why does that matter?
I'm sorry, why are there standards?
Yes.
Well, one is you want to make sure, as we learn more about research and human behavior, we learn more about what you should and shouldn't do. So, for example, there's something called social desirability. People want to create a positive impression of themselves. So when you ask questions, for example, can you be a fair juror? Well, we all want to be fair people, so you're more likely to get a socially desirable response. The initial step on that was all the way back into voting. In California, there was a election for governor, I think it was Davis or something like that, and all of the polling suggested he was going to win. He was African American, and he lost. And that was when they started looking at that, and they saw all these different impacts in terms of like race of the interviewer. All these things affect how people respond. People overestimate that they vote because you can look at voting records and it's inflated. People overestimate they have a library card and a million other things. So those are things like we look at when we craft the survey. We don't want to have social questions that lead to socially desirable responses, order effects, a host of other things.
In your survey, it looks like you have sections designed in your survey.
Mm-hmm.
Sorry, can you hear me? Okay.
Better with the microphone.
Okay, I'll try to stand closer over here. I want to understand this section, these sections.
Okay.
Why do you have sections in this survey?
Sections?
Yes.
Well, one is you don't want things to be jumping back and forth all over the place because it's harder to take a survey like that. You'll have more people drop off, confusion, potential order effects. So we try to organize the survey into sections. So all the key questions on one topic are together, and then the next section changes topics, so it's easier to follow.
What is the purpose of section 3, case awareness and prejudgment? Why is that in there?
So that's the meat of the survey. That's the most important section. So case awareness measures initially case recognition. We craft a recognition question based off of the media coverage. What are the things widely reported that are not overly prejudicial because you don't want to create an order that would stimulate a memory of, yes, I remember that case. So if widely reported A, B, and C facts that you read the coverage and you see this was mentioned 100 times, that's a widely reported fact. So we create case recognition question. Now, if somebody says, yes, I remember that case, I have read, seen, or heard about it, they're asked a prejudgment question next, guilt or innocence question. Then they're asked open-ended questions and then those case-specific items. Now, let's say someone does not remember the case based on the case recognition question. We give them one more fact to see if it'll stimulate a memory. Something neutral that might stimulate a memory. You usually get 1 to 2% more that recall the case from that. If that person recognizes the case from there, they are also asked that prejudgment question and they continue. If they do not recognize the case, they skip the rest of the survey and they're asked demographic questions about media consumption habits and demographics. The next step of the survey after the prejudgment question is an open-ended question. What have you read, seen, or heard about the case? There might be a few others we add based off of these things we might find in the media coverage. And then they continue on to those case-specific items that we've been talking about. Have you read, seen, or heard if so and so?
I want to make sure I understand this and that this is clear for everybody. Those 9 questions that have been the problem last week and this week, if you have somebody who says, no, I don't know that case, do you ask them those 9 questions?
No, they skip to the demographic questions.
Tell me, what are the demographic questions, just to be sure?
If somebody doesn't recognize the case, they immediately go to questions, for example, how often do you read the newspaper? Every day, several times a week, rarely, never, something like that. Then they're asked how often they follow the local news, and then they'll ask a few demographic questions like age, gender, race, ethnicity.
So if somebody doesn't remember the case, you don't infuse information or do any of the things that were brought out last week.
No.
I have on the screen in front of me some of the read, seen, or heard questions.
Yes.
What are these? You don't have to read them all, just tell me what they are.
These are 9 items, which we always use. Have you read, seen, or heard if? And these are items taken from the media coverage that were widely reported. And let me be clear, widely reported hundreds and thousands of times, and potentially prejudicial items. Because neutral run-of-the-mill media coverage is often not grounds for a change of venue. So if somebody knew there were 4 victims, that's not particularly prejudicial, is it? That's a pretty benign fact. But if somebody knows, for example, about a prior conviction that's not admissible, that's very prejudicial. And it might be correlated with prejudgment. And I would like to know that, because if it's widely prejudicial and everybody knows about it, and it's correlated with prejudgment, that would likely have an impact on my recommendations, because that's the type of pre-trial publicity that has been recognized by the Supreme Court, I'm sure the state court here, that is most concerning.
So these kinds of questions, these case-specific questions, you do this in all the surveys that you do.
Yes.
And in this case, these 9 questions came straight out of the media.
Absolutely. And again, widely reported throughout the media, thousands of times.
Now, just to be clear, you gave an example of information that might be widely reported that's highly prejudicial that you would use in a survey. You haven't talked about Bryan Kohberger's survey yet, have you?
What do
You haven't told us the 9 questions.
I have not.
Okay. And we'll get there, but I want to talk about a little bit more about the history of this survey. You told us it had been used for decades. And I think you told us a little bit about some of the other really high profile cases where this survey format, the survey method that's been widely accepted was used. Are some of these cases your cases that you've done these surveys in on this list?
Yes, I used these types of questions in the George Floyd case for Alexander King, who was one of the defendants. There was also a gag order or non-dissemination order in that case. The Parkland shooting case in Florida, there was a non-dissemination order in that case. Used it there as well. Used it in the Pittsburgh synagogue shooting case in Pittsburgh. State of Idaho v. Jonathan Renfro, which was here. State of Idaho v. Gilberto Rodriguez, also used it there. And many others. I've used it 100 times. Dr. Bronson used it more than me because he was doing it even longer than I have. Other experts in the field do it. This is the standard practice.
Standard in your field.
Yes.
And are these surveys, doing a survey like this, is this just criminal defendants that ask you to do these surveys or that have any interest in doing these surveys, or is it other people too?
Other people use the same process as well, including the prosecution and the government.
I think you provided an example in your PowerPoint of the government using this survey process in a case that you worked on.
Yes, this was the Jason Van Dyke case in Chicago. He had been charged with shooting and killing Laquan McDonald. It was like 17 shots was like the famous saying. It was a very significant case, interracial crime, widely reported on. And the government also did their own survey to see if there was any potential bias and followed the same exact process and used case-specific media items. And once again, there was a non-dissemination order in that case as well.
Earlier, you talked a little bit about validity being one of the standards.
Yes.
Tell me how you measure validity in one of these surveys.
Sure. So this is from the professional code from the American Society of Trial Consultants. As I mentioned, we want to look at things like consistency. So we want to, for example, the research tells us the more case or media items you know, you develop knowledge. And the more you know, the more likely you are to exhibit bias. So I want to test that in the survey. That's one of the reasons why I include those case-specific items. I also want to compare what people or that item to prejudgment. So the more people know, are they more likely to prejudge? How about case-specific media items? Is there specific prejudicial items in the media that are particularly concerning? Maybe I'm going to go back to my prior conviction example. If there was a conviction, because I've had this happen in a case, and then years later, that conviction was thrown out and there's a new trial. Well, that's extremely prejudicial if people know about the prior jury verdict. So I want to know, what percentage of people know that detail? And is that related to prejudgment? And most importantly, when you ask the question, have you read, seen, or heard about the case? The open-ended question, do people report it? Because if they don't, and they do know it, well, that's very concerning. And
Yes,
that's
my mate,
the type
yes,
of
I will.
problem we run into in voir dire.
Sounds like that's one of the reasons you have case-specific questions in there.
That's one of the reasons, absolutely.
You heard talk last week, and then you've heard it again today about, can't you just change this survey and take those case-specific questions out and then do the survey? Can you do that?
I would not do that, no.
Can you explain why not?
Because this is based off of 15 years of doing this. I know for certain, and there's research on it as well, that when you ask people an open-ended question, what have you read, seen, or heard about the case? They have a difficult time recalling everything from memory. That's a recall question. The cognitive effort required to recall everything from memory that you know is very challenging versus recognition, which is a much lower cognitive load. Have you read, seen, or heard if? Oh, now I can search my memory. Yes, I know that fact. If I asked you, tell me everything you know about the movie Star Wars, you would tell me a whole bunch of interesting things about Chewbacca and Ewoks and maybe a bunch of other stuff. But I am very confident that you would miss things. You would not tell me every single detail from memory you know about that movie. And then I would ask you something like, did you know that Darth Vader was Luke Skywalker's father? And you'd probably say, yeah, of course, I knew that. But you didn't mention it in the recall question. There's a mountain of research on this. Usually what they do is they have people read like a paragraph or a story, and they ask them, write down everything you recall from what you just read. And then they do a different type of quiz. Did you read that the truck was red? Did you read that there was an ambulance? Oh yeah, of course. And they check that too. And what it shows is recognition rates, the ability to recall information when asked a closed-ended question, is much higher than when you ask an open-ended question. So getting back to your comment or question, if I only ask, what do you know about this case? I know for a fact you'll get things like, well, I remember when it happened. There were 4 victims. There was a knife. I remember there's a delay. I just saw it in the media. Those are the things that people say. They've said it in this survey. They've said it in 100 surveys I've done prior. They've said it in voir dire when I look at transcripts. That's what you see. But when you ask those closed-ended questions, you discover that they know quite a bit more. And that's what I'm trying to look at. I need to know, what do people actually know? And is there information, prejudicial details that they don't mention that they do know when you ask the open-ended question?
And those details, the closed questions, the have you read, seen, or heard questions, are they important to determine if there's bias, that media coverage has created a prejudicial effect, and that there's bias?
Absolutely. If 80% of people are able to recognize a prejudicial detail, and I keep making up because I don't want to upset anyone here, like a prior conviction, if 80% know that detail, but only 3% mention it in the question, what have you read, seen, or heard about the case? That's a major problem. I need to know that because it's an extremely prejudicial fact. Things spread on social media, whether they're true or not, they still impact the jury. Very prejudicial. I need to know if they know that. And I know for a fact in this case that, for example, I'm not going to mention the detail, but for one of them, only 3% of people in this survey mentioned the detail when asked, what have you read, seen, or heard about this case? It was something spread on social media. But when you asked, have you read, seen, or heard of X, Y, and Z, 45% knew that fact. And that fact happened to be significantly related to prejudgment. People who knew it, over 80% of them think the defendant is guilty compared to 57% who don't know the detail. So those are important findings. If I don't include those questions, I can't do any of those analyses. It makes it look like there's not that much of a problem here. People don't seem to know anything. They just say they remember reading it in the paper. I guess we don't have to move the case because they don't seem to know much. And that is misleading, inaccurate, and I would not do that.
Have you had a unique opportunity to kind of actually watch this in real time to see how it works?
I have.
Can you tell us about that?
Yes.
How did you get this unique opportunity first?
So I worked on a case that was called John Fight. This was a Catholic priest in Hidalgo County in Texas who had been charged with murdering a beauty queen. Now, the crime had happened in like the 1950s, and the trial happened in like 2018 or something like that. So all the witnesses were gone, and the defendant was obviously much older. But it was a case that was just weaved in the fabric of the community because it was so shocking. And during the hearing, after doing a survey, one of the things we did is we brought in community residents and did like a mock voir dire to prove this point, to demonstrate. And there was a bunch of things in that case that were particularly prejudicial. So we asked people, tell us what you've read, seen, or heard about the case. And they would tell us, oh, in college, I learned about this case. And I know A, B, and C. And we say, is that everything you remember? And they said, for example, here, I believe so. That's what this person said. Search their memory. Let's see. I believe so. That's it. And then we asked those case-specific questions that you clearly could never ask in voir dire because you'd be poisoning the well. And we asked, for example, did you know that John Fight gave a confession to a priest, confessed to the crime? Oh, yeah, I knew that. And once she said that, it stimulated her memory. Actually, he confessed twice. So now she knows that. The fact that she did not mention in the open-ended question, extremely prejudicial. The Supreme Court has recognized confessions to be very prejudicial for Doe v. Louisiana and a bunch of others. And she knows about it. And then we ask kind of again, is that everything you know? And she says yes. And then we give her another one. Did you know that he was involved in another case? He had actually been charged with attacking a woman in a different church. Oh, yeah. Yes, I do remember that. Once again, she knows a detail that she didn't mention. And for saying, okay, and you didn't say that a few minutes ago, did you? No, that's the second one. And then we asked, having refreshed your memory, are there any other facts that you have read, seen, or heard that you haven't told the court? She's, I don't believe so. So it seems like that's all she knows. Then we tried again, and we mentioned that he had been transferred to another monastery. The Catholic Church was moving him around. And she knows that too. Oh, yeah, I did do that. And we tried again. Did you know that local law enforcement were participating in a cover-up? That was part of the story. Yep, she knows that too. So this was an example of the difference between asking the open-ended question that you can ask in voir dire, what do you know about this case? Where have you heard about this case? And you get an answer. Sometimes people say, I just recall when it happened. Sometimes you get more detail. But when you start asking those closed-ended questions, you uncover that actually they know quite a bit more. And that is the key point in a high-profile case. In the general case, it doesn't matter because there's no case-specific information. What we know is that specific attitudes predict behavior much more than general attitudes. So in a community like this, it's been saturated with media coverage that's prejudicial. We want to know what case-specific details they know, because that goes to bias, and are we able to ferret out that bias in jury selection? And that's why we include those questions in our survey.
I want to talk about Bryan Kohberger's case for just a minute.
Your Honor, again, I'm going to register the objection. This is going to deal with the actual issue of change of venue. It's premature. The state has not been afforded the opportunity to analyze, much less respond to it. So to the extent that the court wishes to allow us to continue, I just simply ask you to give it that reduced amount of weight, because the state is not in a position to respond to any of this.
Okay, thank you. But you'll have an opportunity to respond to any of this before I make a decision.
Not today, Judge. I'm sorry.
Hold on.
Yes,
I'm
sir.
not going to make a decision today.
Yes, sir.
I'm getting information,
Yes, sir.
and then I'm going to consider what you're going to provide, and then I'm going to make a decision.
My point again, Your Honor, is this goes to the issue of a change of venue, not whether or not the non-disclosure order was violated and what we should do about that.
It wasn't.
Two
Shut
separate
up.
issues. The state is not prepared and will not be prepared to address a change of venue issue until an appropriate motion with supporting documentation and evidence provided, and we have a chance to respond to that, which I understand we'll be doing between now and sometime next month.
Exactly.
Thank you.
So shut up. What was the point of
Go
that?
ahead.
Thank you. Dr. Edelman,
What was the point of that?
you haven't finished analyzing the data in Mr. Kohberger's case, have you?
No, the only thing I looked at was supposed to be on the question at hand, which is about these case-specific items, why they're in the survey, and which goes to whether we can continue the survey without them. That's the only thing I looked at, was addressing that specific question.
I'm not going to ask you what your opinion on change of venue is today.
I don't have one. Well, I do, but I'm not done analyzing the data.
Senate, I want you to be informed before we get there. So I do want to talk, though, about Bryan Kohberger's case, and if you've been able to determine if the survey was valid.
Yes, absolutely.
And how did you determine that the survey is valid?
Well, one of the things, as I mentioned, is looking at the social science research, and do we find similar findings? And we did. So we also look, for example, do we have like acquiescence bias? What that means is people are just saying yes to everything. So on those case-specific media items, one of the things you do is you include items that didn't receive as much media attention. That way, you want to make sure, and what you expect to see are items that get a lot of media attention, everybody knows about. So you can see really high recognition rates, 80%, 90%, 60%. And then the items that didn't get as much attention, they're lower, 40% or less. So we want to see if there's variance across the questions, and we see that as well.
Does it help to do the recall questions and the recognition questions to understand whether you have a valid survey? Is that what you're telling me?
Yeah, well, as I meant, those are the case-specific questions. Yeah, those media items. So we test validity by, are those correlated with prejudgment? Are they correlated with media consumption? So people who read more of the media, do they know more of these details than people who don't? The more details you know, are you more likely to be biased? All that stuff. But also, again, like I said, is you want to check to make sure there's variance across those media items, because you want to make sure people aren't just saying yes to everything.
You talked early on about how if somebody doesn't recognize the case, you stop and you don't ask these case-specific media generated items in your question.
Correct. And remember, these media items also come after the open-ended, what have you seen or heard about the case?
Do you know how many people did not know about Bryan Kohberger's case in this survey? The percentage?
I believe it was like 3 to 4%.
And so that percentage of people didn't get the case-specific questions. Is that fair?
The people who did not know about the case, the very few, did not get the case-specific questions.
I want to talk about the open-ended questions and then the have you read, seen, or heard questions. On the open-ended questions, when you say, what do you know about this case? Tell me everything. Do you know about how many things people remember?
Yes, so one of the things we do is we read every one and we track how many details they mentioned. And then we compare those, what did they say, to how many case-specific items they later recognize. So for example, if somebody said, I know 4 people were killed and they found the guy, I would identify like 2 facts, 2 details, for example. And then I would look at those case-specific items later and how many of those items did he mention in the open? And that scenario would be 0. But if he knew 6 of them, that would tell me that he knew 6 details that he failed to recognize. Versus somebody might have known all those details and mentioned all of them in their open, then it would be 0. They reported everything they knew, and they mentioned later on that they knew those items. So I look at that.
You're checking what they say they know in the general open question, and then see if they hit some of the specific questions, and then measuring how many more they actually know when you get to the have you read, seen, or heard question.
And then I compare. And that kind of goes to my John Fight story. I'm looking to see if that is a problem.
What did you find in this case?
I found that 96% of survey respondents knew at least one additional media item that they failed to mention in the open-ended question. On average, people reported 1.6 details when asked the question, what have you read, seen, or heard about the case? However, on average, they later recognized 6 out of the 9 media items, and I believe it's something like 72% knew, I want to say 5 or more.
Boom.
Now, in this situation, did you find out people had a lot of knowledge that wasn't the specific case-related questions? They would rattle off, I know these things, several things.
Yeah, so what I found was on average, people knew at 4.9 additional items that they failed to mention in the open. What does that mean? That means they knew approximately 5 of the media items that I tested later that they did not mention in the open-ended. 5 on average out of 9 they knew, although they didn't mention them. And these are examples. So somebody wrote just what has been on the TV and the papers. That's the common thing you get when you only ask the open-ended question. But that person knew all 9 of the media items we tested. Someone else mentioned the detail. The kids were murdered and they tracked them down. Well, you actually know 6 out of the 9 media items that we tested. Nothing lately knows 7 out of the 9 media items tested. And it goes on and on. That is a very common finding. I find it in almost every survey I do. Between 92 and 96% is the norm of what I see in terms of knowing more detail than they report. And it usually, interestingly, the average is usually around 3 extra media items that they failed to mention. In this case, it was 4.9, so it's higher.
Do you have a way within the survey to correlate prejudicial coverage or bias for guilt with the amount of specific details recognized?
Yes, because I asked those case-specific questions. If I didn't, I would not be able to. Because as you saw, people say things like, haven't seen anything lately. Well, that doesn't really do much for me. I can't analyze that. I can't do anything with that. I don't ask those case-specific items. I can't test the validity of the survey. I can't test to see how case-specific knowledge impacts prejudgment. I can't test to see if there's one particular item that's highly prejudicial that we should be worried about, that should, that's inadmissible. What percentage knows that detail? All of those things are required to do this correctly.
And how do you know that there's prejudgment in a case? What questions do you ask, and when do you ask them to know that there's prejudgment or bias in a case?
Well, after the case recognition question, they're asked, based off of what you've read, seen, or heard about this case, do you believe the defendant's guilty of whatever the crime is? And it's on a scale of like definitely guilty to definitely not guilty. So that's a prejudgment question. I have a second follow-up question, which was actually developed from the
82%.
judge that I thought was really effective. And the question was, would the defendant have a difficult time convincing you that he's not guilty? So it's a presumption of guilt as opposed to a presumption of innocence. This was in Tennessee. It was a high-profile case, and similarly, people would report a lot of detail, and then they'd say, "I think he's guilty," and then that's well, can you be fair and impartial? And they go, "Yeah, I think I could be fair. I can try. I think I could do it." And then the court would ask, "Well, would the defendant have a difficult time convincing you that he's not guilty?" And they'd say, "Oh, yeah, definitely. He could be hard to change my mind." So I use that question because I thought it was really effective, and it happens to correlate much better than the set-aside question with prejudgment and a host of other things.
So do you ask those questions before you say, have you read, seen, or heard these particular?
Absolutely. If
That
you
might be
didn't,
this
you'd be
one yet,
creating
though.
order. So you have to do that.
Will you say that again? You'd be creating what?
Order effects. If I put in like a recognition question, some detail that's extraordinarily prejudicial, I'll go back to my prior conviction thing.
Night
For the same
super.
crime, and then you say, "Oh, do you think he's guilty?" Well, you just told me a jury convicted him. Of course, I think he's guilty. So if you included all those 9 items, and then you ask somebody, "Do you think he's guilty?" You just gave them all this information that's prejudicial. So yes, that would be an order. So we would never do that.
So you ask them well ahead of case-specific
Well-
questions. They have to recognize the case. They have to agree, I know of this case. And then you ask if they already have an idea of what they think of whether Mr. Kohberger is guilty or not in our case.
Correct.
And then you add the case recognition
Jeff.
and you can measure the bias or the prejudicial effect of the media with the incidence of those questions.
What I
right?
look at is the prejudgment question, right? That's on a scale, so Likert scale. And then I can look at things like, is a relationship between the number of details somebody knows and the strength of opinion? Definitely guilty. For example, if you know a lot of detail. I can look at case-specific items, media items. If you knew about X, is that correlated with prejudgment or bias? Is there something that, and so on and on. So that's how we look at the relationship between prejudgment and these different factors.
Were you able to determine if case knowledge was impacting bias in Bryan Kohberger's case?
Yes. So
Probably,
as we
yeah,
asked these
probably.
questions, what we found is that one, like I said, very high recognition rate. So 79% of respondents knew at least 5 of these items. So the idea that we're undermining his due process rights, everybody knows all this stuff. Very high rates. 82% of respondents who recognized 7 of these items or more reported that he's guilty, compared to if they only knew 2 or fewer, only 29% thought he was guilty. And the average was 6.2. So the average number of these details people already know is 6.2.
Given specific case-related bits of information, these 9 have you read, seen, or heard questions, does recognizing one of those questions, if that's oh yeah, I know that one, does that change the incidence of bias, or does that relate to I've already prejudged this case?
It does. And what's really interesting is kind of going back to the open-ended question. So again, I won't mention the detail, but there's one that was widely reported. It's in that affidavit. And 81% of survey respondents knew that specific detail. 81% when we asked, what have you read, seen, or heard about this case? However, on the previous question, what have you read, seen, or heard about this case, the open-ended, only 8% reported it. 8% report it when you ask the open-ended question. 81% actually know the detail when you ask a recognition question. That's significant, and I can only do that analysis because we asked those questions. And 72% of people who knew that detail reported that he is guilty, compared to just 47% who don't know the detail. So that's the kind of analysis we look at. What do these case-specific items look like? If you know this media item, is it correlated with guilt? What percentage of people know that media item? How many people mention it in the open? Is it consistent, or is it perfect overlap, or nobody talks about it, but they all know it? In another one, only I think it was 3% mentioned a specific detail that was on social media, widely reported in the news, not factually accurate, a misrepresentation of the truth. 45% knew it in the survey. Only 3% reported it in the open-ended comment. And it was extraordinarily prejudicial where if you did know it, 81% of survey respondents, if they knew that detail, indicated that the defendant was guilty. 81%, half the sample knew about it, but only 3% mentioned it when I asked the open-ended question. So again, if I didn't ask those questions, and the only thing I asked was the open-ended question, it would appear that people don't know a lot of prejudicial detail because they don't mention the detail when you ask that question. And that is, from my experience, doing post-conviction work, reading voir dire transcripts, coding transcripts, doing hundreds of jury selections, being involved in these cases, coding juror questionnaires. This is the phenomenon that we see all the time. It's nothing new. And the only way to look at it is by doing the survey this way.
Before I ask the question about courts relying on surveys to make decisions, using these surveys to make decisions to change venue, when you talk about things that are in the media that aren't true or might not come in, we've heard a lot about that today. Are you telling me that that's still going to be in my courtroom? Things that aren't true that don't get brought out in trial, those are still going to be in the jurors' minds?
Absolutely. And again, there's social science research on this, looking at the impact of inadmissible content, the effectiveness of judicial instructions, and how it impacts jury decision making. Just because you say it's not evidence doesn't mean it's not prejudicial. Just if I know it, it impacts how I view the defendant. It serves as a filter through how I process information. I might expect to hear that information when I can assume that I will, so it has an impact. One interesting study looked at jurors' ability or participants' ability to recall the source of information. And what they found is after a few days after a trial, people couldn't recall what information they had learned from the media and what information they recalled and learned from the trial. So they assumed stuff in the media came out in trial. The idea that I can cognitively say, okay, I know this prejudicial detail, and I'm going to put it in a box in my mind and never think about it and process everything, and it's never going to affect me. It's just, there's nothing to support that. It's kind of in our everyday lives. That's what our brains like. Think about what's going on today with Trump and Biden and all that. Everybody has strong opinions. The idea that, oh, yeah, well, it's not legitimate or that fact is wrong, it's misinformation, so it won't affect me. There's nothing to support that. There's even research that shows you have people, they read a passage, that they write something supporting a position that was in the passage, and then you tell them that information is not true. It's called belief perseverance or belief persistence. And what they find is even when you tell them that fact is not true, they still have a difficult time not believing it, and it still impacts their views. They still defend it, even then. So there's a host of research on this. The idea that we should only test things that are factually accurate and assume that the other stuff isn't prejudicial is just ridiculous.
So a massive amount of prejudicial media coverage is a factor that has to be considered in a case with this kind of coverage. Is that right?
Yes.
I want to know, though, from your experience, have you done a survey like this that contained these 9 case-specific questions where a judge decided to change venue?
Yes.
Will you tell us about that?
Yes. So in Nichols, there was a case in Washington, and this is kind of what I was referring to. So it was a defendant who had been convicted in 2012 for murder in Grant County in Washington. Later, it was a high-profile case, and then later the conviction was thrown out. It had something to do with jury instructions or something like that. And there was going to be a new trial. And, quite a bit of time had gone by, like a decade. So we did a survey because that fact, knowing that detail, would be highly prejudicial. So what we found was 42% of survey respondents had read, seen, or heard about the prior conviction when we asked that case-specific media item. However, when we asked the open-ended question, what have you read, seen, or heard about the case? Only 12% mentioned it. So 12% mentioned it when you ask the open-ended question you use in voir dire, but over 42% knew about it. Now, you could never ask a juror, well, did you know a jury convicted him of murder if you didn't mention it because you're poisoning the well? And the court agreed and was worried about the effectiveness of voir dire as a remedy in that situation and granted a change of that.
Have you had the opportunity to pay attention to any prejudicial media coverage since the hearing last week?
I have.
What is that coverage?
Well, it created a misrepresentation, false narrative that we, myself specifically, had done something wrong, to poison the well, taint the jury pool, and using language like that. That became part of the narrative. I saw it on Reddit, on social media, in the news, that once again, going into this idea of what the story was, that the defense had done something wrong, debate about whether it was part of their tactic to delay, get him off on a technicality, and so on. And again, what I did, just want to be clear, is the standard practice in the industry, done hundreds of times in high-profile cases throughout this country. There's nothing I did to contaminate the jury pool. Everything I included was widely disseminated by the media in this county hundreds of times, if not more. And most of it came directly from an affidavit that the government released in a press conference and encouraged everyone to report.
Did I tell you what questions to ask?
You did not.
Would you take my advice if I told you what questions to ask?
I would not. And I'll tell you why is, as I mentioned, my role is to be an objective expert to provide the court with information so the court can make a decision on if any remedial measures are necessary. I don't care what questions you want in the survey, and I don't care what questions the government wants in the survey. What I want to do is conduct a valid survey that's objective, reliable, and provides meaningful information that can be used by the court.
Do you believe comparative surveys in other counties would provide the court with more information about what to do when we get to change a venue hearing?
I do.
Why?
Because this case has received a lot of media attention across the state. It's a national case. And depending on what the results are of the survey, I'm assuming if we find that there's grounds for a change of venue here, if that's a recommendation, the response will be, well, there's nowhere else to move it. Everybody's been cut saturated with pretrial publicity, so there's no need to change it. The point of the comparison survey is to address that question. Is there anywhere in the state where you could move it? Maybe there's not. I don't know. But that's the only way to find out. And you have to conduct the survey in the same manner. I don't know if I just ask people what they know about the case and you get general, I just recall when it happened, but you have the same guilt rate. Do they know inadmissible details? Do they know about things from that affidavit? Do they have a lot of case-specific knowledge, or is it just a general awareness of the case? Did they drive by the house where the crime occurred? All these things that make this county unique that you want to test for in other communities. So it's not just a question of general awareness. I need to know what case-specific information they have, what misinformation they have, what media items they've been exposed to. Do they have as much case detail and knowledge as they do here? All of those things. So that's why I would suggest it's important. Without that, the only thing I can do would be to collect the media coverage and assess, for example, like, are there fewer articles published in Bonneville County or Ada County compared to here? That's all we have. I wouldn't conduct a survey that I know is going to lead to misleading information. I'm not going to do that.
To change the survey, would that go against the methodology that you use?
Yes, if I change the survey and I don't include those items, I can't test. Well, do people know a lot of case-specific information that was widely reported? Are those specific items related to bias? Which items do they know? Do they know the ones that were all over social media or not? Like, that's the whole point of asking those questions. What you'll get is, well, I don't know much, but I saw it when it first happened. I remember reading about it a while ago, but haven't seen anything lately. I know the defendant was, arrested or whatever, or things like, oh, I followed it closely. Okay, great, followed it closely. Does that mean they know a lot? I don't know. I can't assess just from someone said, I read the news or I followed it quite a bit. That doesn't tell you anything. That's not meaningful information. So yes, you need to conduct it in the same fashion.
Last week, your professionalism, your work, your reputation was impugned.
I believe it was, yes.
If you're allowed, if the court says, okay, go ahead and finish these surveys, I want comparative county information, are you willing to still work with us?
if we do it correctly, if the idea is we want you to conduct a leading bias survey to get results that we want, then no, I'm not going to do something that undermines my credibility, my objectivity, or do it in any way that's not consistent with the procedures and standards of how we do this.
Thank you. I don't have any other questions, Dr. Edelman, but the state might.
Johnson?
Thank you, Honor. Maybe we'll start going backwards here, or from the back to the front topic. I'm sorry if you're feeling hurt about us raising this issue. I see you were almost breaking down a few minutes ago when we were talking about slide number 33, slide number 31. That's not the intent, and it's certainly, I'm surprised to see that reaction from an experienced expert such as yourself. So I apologize for that.
I accept your apology, but the idea of after working really hard 15 years to develop a credible reputation and being told watching on a Zoom that I am tainting the jury pool and poisoning the jury pool and contaminating the jury pool by doing what's required in standard,
You tell
I'm
him.
not crying. I'm angry.
Okay.
And yes, it doesn't matter.
And please go ahead and be as angry as you like as you continue your work with the defense in this case. It is a fact, though, that you don't know of the 400 citizens that were questioned on this survey. You don't know which ones of them did not already previously know any of the fact-specific representations in your questions. Isn't that true?
I do know because they answered yes or no to the question.
No. Oh, well, okay. Before you asked the question, you didn't know that. Isn't that correct?
That's correct.
And so somebody who hadn't heard the representation in that one slide that you acknowledged was false. Let's see. You acknowledged false that Mr. Kohberger allegedly stalked one of the victims. That's false. You know that to be false.
Which one?
That Mr. Kohberger allegedly stalked one of the victims.
Yes, I was trying not to say that
Boom.
because
But you knew
Boom,
that
stalking.
was false.
Out.
I did.
Yes. And so you have now, for anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false.
That's false. Yes.
Yes. Okay. Thank you. Thank you.
Okay. All right.
No stalking.
And just to follow up on that, early on in your testimony, you testified, I want to make sure that we heard this correctly, that inadmissible or false information can be the most prejudicial information.
It can be.
Yes. And your surveyors put that false information into the minds of people who were asked that question who may not have previously heard it. Correct.
Correct. Relative
Thank
to
you.
the media.
Thank you.
It's mentioned it hundreds and thousands of times.
And just make sure we're clear too, around the same time in your testimony, I believe you testified that you don't care if the information that you put in your specific questions to the people being surveyed is correct. That you said that, didn't you?
Correct. I don't know what you mean by correct.
True or false?
I care about whether or not it's proliferated by the media.
You don't care if it's true.
No, I don't. I
No.
don't care about is it prejudicial.
So it's okay to taint people who had never heard that information before for the end result of identifying others who have and might have bias. Is that a fair statement?
I'm going to object to the questions. He's
He can answer the question.
badgering.
Wait.
Let me finish
Hold on.
my objection.
Yeah, there's an objection.
He's badgering the witness. He's misstating his testimony, and I object.
The witness testified he didn't care if the information was correct, Judge.
Yeah, overruled. So,
May I?
so just
No, that's okay.
one person can talk at a time. And, let's take down the tone a little bit.
Yes, sir.
In other words, shut up. You angry little bastard.
Okay, just so we're clear, the questions, fact-specific questions were propounded to people who were taking the survey. Did not, after asking the question even, qualify the false facts as saying this may or may not be true, or this is actually a false fact. The survey didn't tell them that what they might have heard was false.
First of all, I don't call them facts because they're media items. And then second of all, that would be ridiculous. And no, I wouldn't do that in a survey. Are you suggesting I follow up? Have you read, seen, or heard if he's stalked? And oh, by the way, if you know that, let me tell you, it's not true.
Exactly. That's exactly what I'm suggesting, because isn't that exactly what happens in the voir dire process?
No.
Absolutely it does.
Your Honor, I'm going to object. Argumentative.
Okay, yeah, you don't get to testify exactly about that, so I'll sustain you.
Dr. Elman, have you participated as an attorney in voir dire in Idaho under Idaho laws?
Have I what?
Have you participated as an attorney in voir dire, conducted voir dire in a criminal case in Idaho?
No, I haven't.
He's a prick, isn't he? Why do they keep muting, or are they just not talking?
And just to be clear, because in two places, at the beginning and at the end of your testimony and your PowerPoint, this PowerPoint, you created that as Ms. Taylor. So you adopt what the contents of the PowerPoint speak. Just to be clear, not every fact-specific question that your surveyors asked came directly from the probable cause affidavit. Isn't that true?
Well, to be clear, they're not facts. They're media items.
They're representations of
Your Honor,
fact
I'm going to object.
in the PC
And
affidavit.
Hold on.
I'm objecting and ask that he allow Dr. his answer before he jumps back in.
They're simple yes or no questions.
What was your question?
Oh, yeah. Let's just say, one at a time, okay? Listen to him answer, and we'll be through at some point.
Thank you. So, Dr. Elvin, isn't it true that there are among the 9 fact-specific questions, of the 9 questions, we know which ones we're talking about. Not all of the representations in those questions came from the probable cause affidavit. Isn't that true?
That is true.
And are you aware that under Idaho law, probable cause affidavits in criminal cases become open to the public by operation of court rule? And is arrested and appears in court?
I'm sure that's true. I'm just not used to having press conferences to tell the media to disseminate the information far and wide.
Oh, so let's talk about that. That press conference was
Break.
made prior to Mr. Kohberger's appearance, prior to the release of the affidavit, and the press conference only referred the media to what would be part of the official court record. Isn't that true?
I don't know. All I heard was this is going to be released. I encourage you
To get all
to
over it.
viewers and anybody who's interested in the truth.
By going to the court record and looking at the probable cause affidavit. Isn't that true?
I recall you saying, I want you to go to the court record and look at the probable cause affidavit. And what it did was
You're
secretly.
splitting hairs and meters now, doctor. That's fine. I don't have any other questions.
Okay.
Thank you. So, okay, go ahead.
Thank you. I want to start with the probable cause affidavit, and I think you testified that that probable cause affidavit was spread far and wide in the media over and over again. Do you recall that?
Let me be clear. It wasn't the probable cause affidavit that was spread far and wide. It was details taken from it, put in media stories with editorial comments back and forth in the context of news stories. It wasn't, here's a document from the government that was in the court record. Let me read it to you. That's not how it works. It's media coverage. That's how it's reported.
How difficult is
Taken
it?
out of there, DNA stuff, all the other stuff in there, reported within the context of a news story.
So the news takes this document, takes things from it, and with it, changes it, talks about it, and sends it out.
Yes.
Sometimes, do you think the media gets it wrong after they read something?
Sorry, what?
Does the media ever get it wrong after they read something?
Yes.
And do those stories have any less prejudice on somebody's, on the reader of that media, whether they're wrong or not?
No. And going back to, I don't care if it's true or not, my focus is to assess whether or not media coverage is prejudicial and whether or not it's led to opinions. It doesn't matter if it's true or not. You don't say, well, I won't test all this prejudicial stuff in the media because it's not true, so I won't include it in the survey, and I'll just assume that it had no impact on people. I find it convenient to be able to disseminate a whole bunch of prejudicial media coverage, saturate the community, and then say, oh, you have no right to test the impact of that information on the jury pool. So it's wonderful that you're rating all the bias by releasing it to the media and then saying, no, you're constrained defense, you're not allowed to ask questions about it because that stuff's not true. Or you might have told one person in the jury pool a detail they didn't know. Oh, they knew the other 7 details that are highly prejudicial, but it was that one that shifted everything, and that's going to lead to the contamination. Not the thousands of newspapers, not the media coverage, not the stuff on social media. It was because a survey vendor called 400 people and asked a question that one person or 2 people in that panel, or whatever it was in the 400, may not have known that one detail. They knew everything else. They're already biased, but it was because they learned that one detail, that's what shifted the scales. That to me is just ridiculous.
And if somebody said, I don't know, did you stop?
Yes.
Mr. Thompson was talking to you about the difference between, in the survey, between closed questions and what can happen in voir dire.
Yes.
You're not an attorney, is that correct?
Correct.
Well, what's the difference between what you can do in a survey and what you can do in voir dire as far as your expertise?
Again, I sit in jury selections. I've done hundreds of them. I've done research on voir dire transcripts. I've done post-trial interviews for hundreds of times. So I have a pretty good idea of how the process works. In a survey, I can ask those case-specific media items. Well, someone says, I just recall what was in the newspaper to the open. I can ask a follow-up. Have you read or heard if was convicted by a jury for murder? Could never do that in a voir dire because you'd be poisoning the well, just like in the John Fight case we mentioned. I rarely see during voir dire somebody admits comments on something like, oh, I read this. And then there's a whole discussion and explaining to everybody, well, that's not really true. That fact was just in social media. It's wrong. That is not a normal common thing that I've seen in voir dire.
In your experience, 15 years, you said, doing this work, have you had a situation where you've been stopped midway through your process?
No.
Only in Idaho, baby.
What do you care about?
What's what?
What do you care about? I've heard you say that whether what the media sends out there, whether all of those things, or whether it's a spin off other information, that's not what's important to you. What do you care about in your work?
What I'm interested in is assessing if there's prejudicial media coverage. Inadmissible prejudicial media coverage is some of the most concerning. Misinformation is some of the most concerning. What I care about is what extent of that stuff has permeated the jury pool. What do people know? And do those specific details generate bias, prejudgment? Again, the idea that there can be all this stuff out in the public that's misinformation, prejudicial, that benefits one side, and you're not allowed to ask if people know that detail because you might taint one person who already knows a whole bunch of information. But that, again, like knowing the detail about the stalking comment. Okay, that person knows stuff, but that's the thing that's going to change everything. And now that person's poisoned because they heard it in a survey. But the fact that there's thousands of newspaper articles and television stories and comments on social media, 80% of people in this community have talked about this case according to the survey. None of that matters. It's because I did a survey and asked that question. I mean, that's just I don't even know what to say.
Shut up, Bill.
You still want to finish the surveys if we're allowed to do them right?
I'm sorry?
Will you still do the surveys if we're allowed to do them right?
Yes, if we're doing them correctly, I'm open to continuing. Now, I think this whole thing has created quite a whole new narrative that it's almost wrong that the defense is doing something inappropriate by doing the same standard survey that's been done hundreds of times in other cases, including in Idaho. So I don't know how people will respond because of this and what it's generated, but I would certainly try if we're doing the survey correctly.
Thank you. I don't have any questions.
Okay. So one thing I just want to sort of clear up, because it's come up here back and forth, with the questions that aren't true. And those were not in the probable cause affidavit. And so I think it does have some bearing on the non-dissemination order, because our whole purpose, okay, both counsel were trying to protect these things to the public or to the media. That's, I think, one of the key issue, okay, or the concern about these particular statements. So there were two questions right at the end. And the ethics, okay, of the lawyers, basically this non-dissemination order is real mirror of the ethics in Idaho, especially for the lawyers who are participating in a case like this. And one of the things that is permissive for help in putting this information out to the public is information contained in the public record. Okay, so the public record is a case file that is available to the public. That's the law. And so to then say, well, we have these other issues, okay, of concern that have been spread through the media, hundreds and hundreds and hundreds, as you've said, that we need to, but then it is a tightrope to balance this. So I'm just not accusing anybody. I'm just saying this is one of the things that's pushed or pulled both sides apart and puts me in a very difficult situation. Okay, trying to for everybody. Okay, so that's what that's about. I'm not asking you to answer anything.
No, I'm just trying to think about a solution.
I don't know if there is a solution. Okay, it's out there, but it does have some bearing on additional surveys. And what you're saying is, if you can't use this or apply the surveys that you want to complete, that you need the same questions. Otherwise, it's not legitimate.
Yeah. Well, let me ask you this.
Okay, so if you have an answer to that, that's.
Let me ask you this one. So if you said you can ask certain case, like media items, like the other 7, for example, that may come from the record, that's a possibility. You can still measure what we're talking about. These specific knowledge, when you ask these questions, is high. The more you know, the more likely they are to be prejudiced and biased. And you see differences in the ADA count or a different count. Now, you have to acknowledge there's these other stuff out there that's highly prejudicial. And we will not know if the rate of awareness of those are as significant as they are here. So then it's an unknown. So if the argument is, well, it doesn't look so bad because all I know are the things in the affidavit, for example. Well, there's this unknown out there again, because those items happen to be some of the more prejudicial items that we found.
Yeah, this is a death penalty case. And so when we're talking to jurors, we're going to probably talk to a lot of jurors individually,
Sure.
and it's gonna be on the record. And we're gonna talk about them, about what they think or what they've heard, in real detail. So there's that, okay? So I guess I'm kind of wondering too, in terms of, all the people that may have been called that didn't pick up the phone or don't want to pick up the phone because everybody knows, okay, that, oh, I don't know this person as my phone is ringing.
Yeah.
And I'm not, and then there are lots of people, including me, that would never answer a question, okay, on the phone. So how do you deal with that? How do you balance that? There could be, out there in Latah County that say, I don't want to say anything about this.
Yeah.
How do you factor that?
Well, so you have two things. So let's unpacking both those. So the jury selection question, like I'm sure you've done a million of these. I've done quite a bit. I've done a lot of high profile ones. And from my experience, asking people in the general case, like a DUI, what do you think about DUI? And they tell you generally I'm against it. That doesn't, or I have a big issue with that or whatever. Can't be jurors because it's a general attitude. It's nothing case specific. And there's hundreds of studies that show general attitudes are much less predictive than specific attitudes. This is different and unique because we're talking about attitudes and beliefs specific towards this case. That's a whole different animal. And that's the unique nature of high profile cases. So when you talk to people individually, you still have the memory issue. You still have the you will not elicit everything that juror does. It's just memory does not work. It doesn't matter if they're under oath, private. There's so much research on it. Our brains don't change just because we're under oath. They work the way they work. Your other question goes to response bias. Like, what's the response rate? Is there something unique about people you miss and so on? So there's a lot of work on that. And one of the things we do is why we collect like demographic information is to see groups. Are we overrepresenting one group or the other? If we are, is there a relationship between that factor and bias? And there's a lot of research on response rates, and what it finds is surveys that have high response rates where like everybody takes their survey, and surveys that have low response rates, where it's like less than 10%, and you compare them with public opinion polling and so on, politics. Find in most instances, the results are the same in surveys. So high response rates are not necessarily correlated with more reliable, valid survey findings. And that's something they've done a lot of work on because survey rates or response rates have gone down quite a bit. I think yeah, they have. For sure.
Well, I mean, so it could be that you're just getting people who like to talk on the phone.
Sure.
With strangers.
Yeah, and from this case, I think people are so invested in it, like a lot of unique things. So people, talking about what's happening, they're very invested in this case. It's unique. It's a small community. It's not surprising. But just what I'm finding, there's so much prejudgment, detail, and so on. I don't think I think it's fairly representative of what you're going to see. Almost everybody in this jury pool knew about the case, like comparable to like the George Floyd case. The bias was the same in terms of comparing it, not to Chauvin, who was the one George Floyd, but Alexander King, who was another officer on the scene. Like the rates are similar to that. So that was another high-profile case that was a lot of tension and stress, and so on. And we still got very meaningful data. And we've done this so many times. Like you kind of understand, like response rates are going to, but there's nothing to indicate that, for example, we're missing an important group. And if we were, we would weigh the data to account for it. So there's just
So in Latah County, it was about 1% of the population.
Yeah.
So hypothetically, if we say, one of the counties that are interested in is Idaho, which is biased.
Yeah.
For other reasons too. But would it be 1% of the population in Boise? No.
So
Okay, so that's I was kind of wondering about that. You have to talk about 2,000 people or something. Okay.
can I explain how that works?
Yeah, go ahead.
Yeah, so it's a great question. So You can take a small sample and generalize to the population if it's done correct. So like if you look at surveys of the United States, this are similar to what we did here. Maybe it's 1,000. And now you're generalizing to every city, county, and so on across the country. Everybody has a known probability of being selected. How you pick your sample size, it's called power analysis. So remember, you know how you see polls that are like, you'll see a number like 90%, and they say plus or minus 5%. So it's either 85 to 95%. Basically, it's plus or minus. That's kind of the industry standard. And you take a conservative approach. So let's say you ask a yes or no question. You would say 50% would say yes, and 50% would say no. So that's a lot of variance. So that's the worst case scenario. How many people do you need to talk to so if that happens, your confidence interval is plus or minus 5%. It's kind of and that comes up to 400. So if you did 8 a county, it would be 400, and your confidence interval would be the same as it is here with a smaller anyway. So as long as it is using the general concept of a randomized sample, you can generalize that population with this.
So kind of interpreted this, one of your answers just a moment ago about the getting rid of the questions that came from the media that did not come from the public. Well, from the public, but not legal part. Could you go ahead with that and have legitimate data?
So I think you have the 9 questions. So if you look at it, are the other ones okay? Are you telling me there's 2 that you would like to exclude and keep the other 7?
Well, maybe. I'm not, I haven't made a decision, but I'm just wondering if, I mean, at first in your testimony, you said, well, if we can't, I can't do it without doing the same questions. That's one of the problems, okay? The part of this argument. I mean, if
it's only a problem
maybe
with Bill.
it can be done, sort of sending information out there that is false, that might, affect people, or looking into that, or thinking that it is, they believe in it, even though they shouldn't. Is that something that can be done?
Well, if you do it that way, you're down some things that will arise. And again, the thing I struggle with, and I understand the public record dissemination, so we've done this before. The thing I get to is like, we're not really disseminating it. We're asking if people know about detail that has been disseminated through the megaphone of the media. What people know. I'm not trying to pass on information through a megaphone. So we're talking about 400 people that are talking to out of the county of 500,000 or something, Ada County. The plus the risks and benefits of doing it that way. It seems like there's a very low risk of undermining or contaminating the jury pool when you're doing that versus the risk getting a huge black hole of, well, we don't know what percentage know this highly prejudicial detail. Like, what are the odds, or like what impact is doing a survey going to have on the jury and the community relative to the media coverage that's already out there? So
Do you ever put a caveat on the beginning of the questions where you say, well, we want to understand as we go through these questions that we're not just determining guilt or innocence. We're not determining false or true. We just are interested in our answer to our questions, and we want to be careful that we're not sending out something that we are not going to understand.
So yeah, so we do always, there's an introduction, and there's no right or wrong answers to any of your questions. You could always say no opinion or I don't know to any question. It's going to remain anonymous. We're just interested in your views.
Until Bill Thompson gets their numbers.
That section with those 9 items. Usually it says you may have, we're going to go through some items in the media. You may have reported some news already, but we're interested in what you've seen or heard. We can add a caveat to that, like some of these may not be true, if that addresses it. Some of these things were, not all of these media items are factually accurate.
Sure. People pick up the phone for somebody and they think, you know, somebody with authority maybe, and they think, oh, well, this is really kind of the beginning of the trial or something. I mean, people misunderstand all kinds here, right? So
We could certainly tweak the intro. Now, we don't just jump into it. We don't say we're an authority, you know, it's usually,
no, I know you don't say that. I just
Yeah,
think,
yeah.
you know,
So we can work on the introduction if that would address some of those concerns so that people understand. Not everything in the media is accurate, but the thing is, like, if we're gonna say, for example, not everything in the media is true, they get a lot of things wrong. You would not want to say that before you do the pre. You can do that after, when you do the case specific items, because what I want to know is, what are people's opinions about guilt or innocence? I don't want to give them instructions and then get socially desirable response in the survey.
but you don't sort of measure it, this person as their bias until you get into the specific questions, specific stuff, because otherwise it's just yes or no, and you can't determine bias just from.
So the prejudgment question comes before the case specific media item questions, because then you would create bias. If I read those 9 items and then I said, okay, do you think he's guilty? I just told you all the stuff you might not know. Yeah. So the question is, do you know about the case? And then it's based off of what you've read, seen, or heard about this case. Do you think so-and-so is guilty of murder, or whatever the crime is charged? And it's on a scale. Yes, definitely guilty. Yes, probably guilty. I know, probably not guilty. To know. Based off of what they've already been exposed to without you giving them anything. So they should be on what they've seen in their home. And then you ask open-ended questions like, what do you know about the case? And then other things. And then you get to those case-specific media items.
And that's when you can theoretically measure bias.
Yeah, well, I mean, I correlate those recognition items with the prejudgment questions of earlier, right? So
Correlation doesn't necessarily mean causation.
Yeah. Well, they're chi-squares, you can do different things, you can do linear regression, whatever you want. But what I want people who report later on, they know that detail, did they report stronger views of guilt? So if, like, I'll give you an example, like if you only knew 2 of those items, prejudgment was only 21%. So if you only knew 2 out of the 9 items, most people had no opinion. Versus if you knew 7 or more of those items, it jumps up to 82%. So that's telling you, like, the more facts you know, the more case knowledge you have, the stronger your opinion is, right? And that's what you see in literature, that's what you expect.
So if somebody was being told, oh, that was just all false information, would that bring down the bias?
In what?
Measure? But you were saying earlier that it's kind of pessimistic, I think, maybe, that maybe absolutely correct, that once people have an opinion, they're not going to let go of it, even if they get the truth.
Yes, yes, it's called belief persistence. There's a bunch of research on that.
That's kind of going around the
Yeah.
political
And we see it.
things right now.
Yeah, like if you talk about, everybody has an opinion of Donald Trump, so. If
I'm
you
not going to say it.
Yeah, I know, but if you,
Neither are you.
yeah, so.
All right, so thank you for that. Any questions online?
Your Honor, I don't have any other questions for Dr. Edelman, and we do have a summary for the court at the appropriate time.
Okay. Mr. Thompson, anything online? Okay.
Yes, sir, thank you.
So go ahead, Ms. Taylor.
Fuck me, here we go.
Ms. Matloff is going
Oh,
to
you
give her
know what?
summation.
Okay, just 1 second. I'm ignoring the court reporter, and I'm just so immense in this that I need to fully maybe rest. Are you okay?
Yes.
Okay. Okay. Thank you, Dr. Edelman. Appreciate your testimony there. So, are you okay? Yeah. Okay, great. Okay, let's go ahead.
Thank you, Judge. I realize it's late in the day, and I will tell you that this takes about 9 minutes for me to sum this up. But I do want to talk about something in advance because you're asking questions of our expert about his process and changing the process that is impacted in the court law. And the United States Supreme Court law requires that part of the analysis for the court on presumed prejudice include false media coverage. It's not enough for it to be all truthful media coverage. So before you start suggesting that an expert change his methodology that's accepted practice, it's really important that you go back and look at Skilling and Haddon and the lineage of cases that get us to venue and what the court has to decide in determining. The question you asked, be answered today, is where do we go from here in the survey process? I want to answer that question in two parts by summarizing what we can do and what we can't do. We can and we need to finish the process that the defense undertook. It was completely valid. It was standard in cases like this. Dr. Edelman is an expert in this field, and he has done this jury research and this work for 15 years. Nothing about the format, the methodology, the questions, or the fact of the survey itself was wrong. You've talked about two questions that you are describing as false because they're not in the affidavit. But if you look at that affidavit and what the media has done with those things is they have created a narrative based on the facts that are represented in the affidavit. Now, I would agree that there's a lot of information in that affidavit that is just flat and not true. But if we focus on where we are right now,
Oh, that was a
our
statement.
representations in the affidavit about multiple trips to Moscow from Pullman and a return trip to Moscow from Pullman in the morning that lead a reader to the word of stalking, that you have a problem with that word being included. Reflect back on the case law in the United States Supreme Court about showing false information, but also look at that affidavit and the way the media has construed that in its representation, its reporting that is so prejudicial. Because the basis for this spin, the foundation is right there in what you are describing as the public record. Now, I fundamentally disagree that the only public record in this case is what's there on the 12-page docket. The public record in this case that the entire nation, the world, and looking at, and especially Latah County, and construed out of that public record.
So can I ask you a question about that? This public record thing is really kind of circling around because what's the purpose then of the non-dissemination order? If everything out there in the public is the public record.
Well, my understanding, Your Honor, is that it's the one of the primary issues was the credibility of the person that is out there speaking. We did not want 9 officers out there talking about police reports and disseminating that. We didn't want the prosecutor doing press conferences like we saw on 12/30/2022. We didn't want the defense getting up and doing press conferences based on the information because we have information that no one else has, and we are consulting with experts that the public doesn't know about.
Bingo,
and so
Sussy.
we have a level of credibility don't have. And so that is my understanding of what we're trying to get a hold of. And it's been pretty effective in this case until this valid survey that happens in high profile cases has been construed to be something nefarious, which it absolutely is not. As you've heard, Boston bombing, the Parkland shooting, the Colorado theater, George Floyd, hundreds of cases going back decades. Dr. Edelman's declaration and now his testimony are uncontroverted evidence before this court on this issue. It's the actual evidence that the court, and finally today, you're getting informed about the validity and the science behind the process. Nothing that was done is worth the hysteria, hyperbole that keeps getting expressed in this courtroom. The questions asked, the topics, the order, the open-ended, the specifics, they were all done using information that is out there for everyone to see. And the research methods used to determine what was out there is the traditional way and the scientific method that experts in this field use, just as Dr. Edelman testified. And to be sure, the purpose of this is to give you information so that you can make an informed decision about venue. It's not for a nefarious purpose. It's to arm you with facts and information so that you can apply the United States Supreme cases that have been adopted in Idaho and determine whether or not there's presumed prejudice. You know, when we first started talking about whether or not there was going to be this venue sooner rather than later, Ms. Beatty for the state said at least 3 times, Judge, they can't just come in here with affidavits. This case law says that they have to have more. The more that we are gathering to provide you, at least part of it, is this survey. In terms of the proposition that this survey taints the jury pool, first of all, you heard from Dr. Edelman that if someone answers they don't know, a second question tapping into that is asked and the process stops. There's no other questions other than demographics because they don't want to poison anybody who doesn't know. So for there to be this proposition that all of these questions, these 9 questions that are later on in the process were put out there intentionally to poison the jury pool, that's just flat false. And the other point is you can't taint what's tainted. When statistics are, as it relates to this county, 97% of the people had familiarity with the case. 79% of the people knew 5 or more prejudicial and false media reports. 81% of those who had heard about the stalking had determined and took a position that Mr. Kohberger is guilty. These people that were surveyed didn't form the opinion when they were being surveyed. And they didn't then go research their already strongly held opinion because of the survey. These are deeply held opinions in this community within this jury pool. The Lake County citizens have accepted the information placed before them by state actors. It's not just Mr. Thompson that did a media report and talked about the probable cause affidavit. Chief Fry, the coroner Kathy Mabbitt. We've got search warrants from Pennsylvania out there in the public warrants in the public record out there from Idaho. We've got all kinds of pleadings. This is all information that's put out into the media. And having the state now claim this moral high ground is an oxymoron. It's a complete oxymoron for state actors to put this information out in the public and now say, hey, wait, if you want to ask, believed the information that we put out there, you can't do that. That harms Mr. Kohberger. We as a defense team have the obligation and frankly the privilege of defending Mr. Kohberger and defending his right to a fair trial. And in doing so, in arguing that venue should be changed, we have to show you that there is presumed prejudice in this community. And since we have the burden of this, and you now know essentially from this expert, presumed prejudice in Latah County, you have to ask yourself, do you want more information to know where the better venue is? And that takes me to the next point, which is what we cannot do. You've heard Dr. Edelman say that it goes outside of his standard of practice and the scientific method that has been used in hundreds of cases to take your ideas about what should be in questions, to take the state's ideas about what's being in questions, should be in questions in the survey. He follows a process. That's the process that he needs to follow because he has to provide the court with apples to apples comparison. Another issue that has was addressed last week that I want to touch upon, and there are two, is this concept that if we just done a juror questionnaire, it would have addressed. At the stage that we're at now, which is setting ourselves up for and preparing for a venue hearing, we have to justify a venue change. The standard that you're going to be looking at, according to the Supreme Court, is whether or not a presumption exists where the record demonstrates that the community is prejudicial, false, and inflammatory media publicity about the crime. The case law mentions false media publicity about the crime. That's what the survey assesses now. Another way to determine actual prejudice is a questionnaire, and that is done prior to selecting the jury. And at that time, individual bias of the prospective juror. There are different methods used at different stages of the case. And right now, the proper method is a survey. Another solution that you mentioned last Thursday was simply to strike 400 people surveyed from the veneer. And I want to talk about that. First of all, that doesn't address the problem that's very clear that we have in Latah County. And so if you extract the percentage of people that have drawn a conclusion about Mr. Kohberger's guilt, if you extrapolate that to the county with numbers like 81% have concluded if they are familiar with the media information about stalking, there's no prospective jurors in this county. You mentioned, this is 1%, but there's much more analysis to what the prospective jury pool is here. First of all, the jury commissioner, I think you talked about her when we were talking about whether or not jury trial was going to be speedy trial was going to be waived. You said, I think it had expanded the pool to 1,000. Am I right about that number?
I can't remember. It was maybe more.
Okay. So if you extrapolate that we know a prejudice exists, I mean, that leaves us with a very small jury pool for trying to do voir dire in a death penalty case. But if you look at the population of a whole, what the U.S. Census says about Latah County is that almost 18% of the population here is under the age of 18. Almost 18% of the population here is over the age of 65. That close to 35% of the population that's even eligible to be in your jury pool. Second, and more importantly, I can't find statutory and legal authority for you to strike 400 people out of the veneer up front. I found the opposite. As you know, the clerk or the jury commissioner pulls from the jury pool that's approved by Idaho Code. And this is a really important section in Idaho Code 2-202. It is the policy of this state elected for jury service be selected at random from a fair cross-section of the population, and that all qualified citizens have the opportunity to be considered for jury service.
Rest assured, I was just being sarcastic.
Okay. Well, I took your sarcasm to heart, I guess, last week.
I apologize.
Because it was a very serious day, right?
Every day is very.
last Thursday was in particularly a tough one. I think we can all agree.
There's gonna be more tough ones ahead, I'm sure.
For sure. And we all need to give each other grace.
Thank you.
I will end by saying this. Our defense team firmly, and I mean firmly, believes in Mr. Kohberger's innocence. And right now he's being held to have a trial in a case that believes that he is guilty. In this country, we pride ourselves on a jury system that doesn't stand for that. In this moment, I see that you have two choices. You can let us continue and do comparative surveys as planned, or you can maintain the stay. And at the venue motion, you will hear that the data for Latah County shows a presumption. You will not have comparative surveys to fully inform the court. As you consider this, there is absolutely nothing that gets risked if you change venue. But if you deny a change of venue, Mr. Kohberger's constitutional right to a fair trial is denied. There's only one human being in this case with a right to a fair trial. It's Mr. Kohberger's and his alone. There's no legal right of this community to have a jury trial here. Thank you.
Thank you. Mr. Johnson?
Mic drop.
Thank you, Judge.
Oh, fuck. Here we go. An hour of listening to this twat moan.
Let me bring this back into perspective. Our motion deals with the court's non-dissemination order. It was agreed to by the defense. In fact, the idea of the non-dissemination order was initiated by the defense with their February 30th, 2022 motion for a non-dissemination order to prevent extrajudicial statements. That would be statements outside of the public record, which is the court record, that have a substantial likelihood of heightening public condemnation of the accused. And the state's position is that the fact-specific questions, and I understand from Dr. Edelman why the questions are asked. I understand his explanation. It doesn't change the fact that we have a non-dissemination order that specifically prohibits that kind of dissemination of facts, specific facts about this case. Facts that include those acknowledged from the stand that they are not true. Which, interestingly enough, I look at the PowerPoint and slide 15, which talks about the American Society of Trial Consultants Professional Code on Venue Survey, says false facts should generally not be used to test accuracy of other responses in venue surveys. So if false facts are used, they must be clearly false. There's no possibility that the respondents who know about the case use false facts with true facts that have been publicized.
He's ignoring that.
We have an inconsistency there, which frankly is logical. It makes sense. And the state is coming from a position of being practical and trying to use common sense here. As I listen to what we have heard today, and in part from last week, it seems that the position of the defense is it is okay to risk tainting jurors in order to ascertain bias of other potential jurors. And I'm not sure that's the way this court should do business. If we accept what the defense is suggesting at this point, and again, we are not arguing venue today, and so I'm not going to try to get into all these numbers and all those sorts of things. We'll save those for another day. But if we were to accept that we have perhaps on one issue 20% of jury pool statistically available, well, that's more than enough people to select a jury from. So it's not nearly as overwhelmingly compelling as I think
Spit it out, will you?
being suggested here.
Judge even looks like he's thinking, what is he fucking talking about?
I want to be clear again. Ms. Massoff used the word nefarious several times, suggesting the defense was, or that the state was accused of nefarious, and we are not, Your Honor. I
Not.
I am
We're
not suggesting that there was any ill will or motive by anybody over here. What we are suggesting and what we believe that the record shows is that this court issued a specific order prohibiting the dissemination of specific types of information, including the identity or nature of evidence expected to be presented, including the performance results of the examination or test. There's no question that those 9 questions included violations of no contact order. That's what we're here about. And apparently there was some miscommunication or misunderstanding about the integrity or the importance of the non-dissemination order. It sounds like today that maybe because these types of surveys are common nationwide, then the non-dissemination order really doesn't matter, which is a little disconcerting, but I don't care about what happens anywhere else. It's what happens in Lake County, in this court.
And you want this trial
It's
to
far
happen in
above
this
my pay
county.
grade to go and analyze what happens in a big city or some other part of the country. I know Lake County. That's where my interests are. That's where our interests are here. On the issue of whether the survey can be changed, I think that does present some challenges based on what we've heard here today. We just back up, and if the defense wants to pursue the survey, they do a new survey with a new group of people and take out the objectionable questions. And then once they've done that, they can proceed to do that identical survey in other veneers around the state, whichever ones they want to select. And that would be the proper way to do this. Now, we may hear, oh my goodness, that's going to consume time or that's going to consume a lot of money. Well, I'll tell you right now, I don't care. If it can't be done right, or if that's what it takes to do it right, then we need to do it. This is a big case. And the finger for this cannot be pointed at anybody but the defense.
Here we go.
I'm not suggesting an evil intent, but the practical effect of the decisions made on behalf of the defense was to ask these questions and to create a situation that we've been having to deal with now for 2 hearings over the past week, well into the evening on a Wednesday.
When I should be down the pub.
That's the way forward,
God damn it.
Judge. Thanks.
Go ahead.
Judge, I'm just gonna end really quickly with this. We didn't violate the non-dissemination order. You know, the information that now he's calling facts, you know, he's flip-flopping between whether or not it's a false fact or a fact that's in the survey. The information that was put in the survey is based on the public record and information, the way that the state and state actors put information into the public record been disseminated, and we have not violated that order. And I do resent being accused of that.
I appreciate that. I mean, those 2 questions were not in the public record. Okay. They were. I mean, they came out, but that was not the court. I mean, where it came from. It just came out of the media or somewhere. Who knows where it came from? But I don't think there's anything, not that I'm aware of, in the public record that said anything about that, about your client. So here we are. I mean, that happened. It's kind of unfortunate. I totally understand the reason to have false information out there, but I mean, I have to just want to clear that up. The other things, that's all from the public record. I don't question. But Anybody tell, if you can find somewhere in the public record that those, claims were made, I'd like to see it. But I think both sides had a different definition of what public record is. They've looked it up. It's the public record from the case. So that aside, I appreciate the testimony, the arguments from both sides. I think it's a challenging issue. We're gonna have to struggle through and figure out what to do. And I understand that there's some urgency to get that out, so I'll do my best. Probably not gonna be this week. So, anything else we need to talk about? Ms. Taylor?
Your Honor, just the logistics of decision is yet to come. We can't continue the surveys. And we've got deadlines next week, midweek for briefing and the motion for change of venue for May. So I'm wondering if we want to consider resetting that motion and that deadline now. I still want to keep the hearing on May 14th. We have a motion to compel already filed to be heard that day. So we could still use reserved court time to make some further advances in the case. But I'm concerned about being properly prepared for the change of venue decision, especially if we're allowed to continue with work.
Sure. And I told you last week that I would give you more time. I want to be fair about it. So you want to change that hearing? You want to leave the May? We're set on May 14 at 1:30.
We have,
You want to keep that for the motion to compel,
yes, please.
but you want to move out the hearing on change of venue.
I believe that's the only prudent thing to do at this time. Yes, Judge, I think that we should, based on some availability of team members and experts, though, I think we're not ready, or we won't have the team available until the 4th week of June for all of the people that are necessary.
You want to just wait and just talk to each other, just, have a hearing again.
Judge, we're going to have an agreement on the change of venue issue. If I thought we could come to an agreement on that, I'd say, yes, let's not set one, let's talk.
Oh, no, I'm not suggesting that you would agree on agreement on change of venue. I just mean changing the hearing, the date.
Your Honor, we would suggest the last week of June, and if the prosecutor's ready to weigh in on that and the court's ready, we'd prefer to get.
Okay. Mr. Thompson, what are your thoughts?
Yeah, I think it would be appropriate to reset the dates, and really what's going to drive this in part, well, in large part, will be Your Honor's decision on what we've been talking about today. But I think it may be prudent for the court it would be prudent for the court to vacate the hearing on a motion for change of venue and prepare to reset a briefing schedule and a hearing date on the motion for change of venue to a reasonable future time.
Okay.
To allow act to whatever the court's decision may be, and I don't want the court to feel pressured on the timing of its decision. I'd rather take the time to do it right than to rush things and just bollocks it all up.
Well, I won't rush it, and I will feel the pressure.
Appreciate that, Don.
How about we set this for 1:30? We'll make a hearing on change the venue and reset it for January 27. That's a Thursday, which seems to be a good day for this generally, except today. What did I say? June.
Did he say
Sorry.
January
Your Honor,
27th?
It's a long day. June 27. I thought you said the end of June, right?
June 27 is perfect. I am thinking though that we should maybe schedule for a full day.
Super fan.
We estimate, and we are well beyond that now, and we anticipate testimony.
Does 10 o'clock, will that work?
It will, thank you.
Okay. That work for you, Mr. Thompson?
Yes, sir, we are available that day, at least those of we who were right here.
Okay, oh, and that includes Ms. Jennings?
And hopefully Ms. Beatty and Mr.
Well, I'm gonna ask them next, and then I'm gonna go to Ms. Massa.
I'm good.
Okay, great. Okay, Mr. Nye and Ms. Beatty?
Yes. As well.
Okay, perfect. Okay, 10 o'clock, June 27. Okay, is there anything, oh, yeah, briefs. What do you think, Taylor? I mean, I know you can't know until I give you a decision, so.
Your Honor, the briefing schedule that the court gave us was roughly about a month prior to the hearing. We could try that, but if the court's decision takes a while, and if we're allowed to finish our surveys, then we might have to have some time to do a.
Sure. I'll be flexible about that. Let's say hypothetically that we have more surveys, then we might even have to push it out.
That's possible.
Yeah. Especially, well. Yeah. Mr. Edelman, Dr. Edelman told me that, you don't necessarily, if you go to a larger population, that you have to have a percentage of it. It's just. And with, I think, the magic of statistics.
Your Honor, if we're allowed to finish what we started, we think from the time we could get it going, it would be 3 weeks. And then Dr. Edelman would need a bit of time to assimilate the data into a report.
Do you think, if all went, you could have your briefs or whatever other information by May 31st?
Yes, yes. Your Honor, with a caveat, unless there's a long delay.
Caveat, okay?
If there's not a long delay in me knowing what we can do, yes.
Thanks. What do you think for the state, maybe a deadline of June 14th?
I think that Ms. Beatty is going to be handling the venue issues. So how about we ask her?
Okay, Ms. Beatty?
And Your Honor, Mr. Nye and I will both be handling that, but that works for us.
Okay, fantastic. And then maybe a reply by June 20? You think?
We can do that.
Okay. I'll give you time to look at all that before the hearing on June 27th. All right. Thank you for your patience. Anything else? Then we have to talk about this one
Yes, Ken.
motion. You said we'll put it at the end of the case. end of the day.
Oh, the prosecutor's filing, yes, I'll take a
Yes.
look at that with him before I
Okay.
leave the courtroom, Your Honor.
Thank you,
All
Danny.
right. Is there- Go ahead.
If the issues that I have, if they're redacted, then we'd have a stipulation.
Let's see if we can do that.
You two can.
Yes, sir.
All that. Okay, anything else then? Ms. Taylor,
No, Your Honor, thank you.
Mr. Thompson?
No, sir. Thank you.
Okay, thank you for everybody's endurance and have a good evening. Thank you. Sorry.
Okay, now, mate. Well, I never. That was mental, is what that was. It's now 20 to 3 in the morning. So we will call it an evening or a morning, whatever it is. I think my brain is half switched off. And we will come back. I'm gonna do a live at around 12:30, 12:45 PM tomorrow. Or today, actually. Yeah, like today. And we'll have a chat about it. Let me just pull that screen back. Pull that back. And there we go. The mods. I think we need to give the mods a round of applause. That was absolutely mad. That was mad. But thank you. Well done. That was some craziness, that was. But yeah, like I say, we will come back in a few hours' time and have a chat about that, because that was absolutely mental. So yes, thank you to everyone who came in and watched it with us. Thank you very much to the mods. Again, that was like Ken said, I think that was the first live that we've done that has felt like hard work. But we made it, we got through, and yeah, we done it. We done it all. We was here for just over 3 hours. 3 hours. Mental. Thank you, everyone. Enjoy the rest of your evening. Get some sleep. And I'll meet you back here in a little while and we'll have a chat about it. And yeah, do that. Take care. Love you all. And I'm out of here. Peace.